Good morning. This is the Colorado Energy and Carbon Management Commission. It is November 15th. This is a Wednesday, and this is our business agenda, and we will start with a roll call.
Thank you. Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Ray.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Good morning to the 5 of you, the 6 of you, the 7 of you. Good to see everybody. Departing from our regularly scheduled programming, I would like to call upon the hearings manager, Thomas, for an introduction.
Thank you, Mr. Chair. I'd like to introduce our new hearing officer, Stephen Smeltz, to everybody. Mr. Smeltz, if you want to go ahead and give a brief introduction, we're very excited to have him.
Good morning, commissioners. Pleasure to meet everyone virtually. Commissioner McGowan, I picked up on that Taylor Swift reference, and I appreciate that from earlier. Director Robbins, also, I hope the fish continues to get larger with every retelling. I appreciate being able to come and work here for everyone. I worked in a small oil and gas firm out of when I graduated law school. So I've been in front of the commission during rulemakings in the past. I also have some experience in government work as a prosecutor. And so I'm familiar with kind of litigating legal issues. And I look forward to being able to put those two skills together here and essentially work for the commission and the state of Colorado. Thank you.
Excellent. Great to meet you, Mr. Smeltz. Look forward to working with you. You're in a exciting time here for the ECMC as we grow and expand and continue our good work on protected regulation of oil and gas. So we look forward to hearing from you, and we'll make sure to look forward to your first introductions, et cetera. So thanks for being with us.
Thank you.
All right. Next is commissioner comments. Does any commissioner have comments? Seeing none, next is public comment. I believe we had Ms. Chitor who signed up for public comment. If we could elevate her, if she's with us.
We did, Mr. Chair, and she just texted me and asked for the link. So I'm working with Ms. Amaro to help get her the link to our hearing. Oh, there she is.
Quicker than you are. She's already with us.
I mean, Angelica is quicker than me.
Good morning. We recognize you for public comment.
Good morning, everyone. Hello, everyone. Hello, Karen. How are you doing? Thank you for taking the time to listen to my inputs today. So, the 300 series rules, or like the SIDR data, considers the water, soil, air, terrestrial, aquatic, and wildlife resources and ecosystems, noise, light, etc. But nowhere land or ground heat or surface temperature is considered. And I will explain what is ground heat. So when oil and gas is extracted, the voids fill with water, which is a less effective insulator. And this means that more heat from the Earth's interior can be conducted to the surface, causing the land and the ocean to warm. So the oil and gas extraction contributes to climate change as surface temperature rises. And not only the land, but also the groundwater gets warmed up. One of the fastest rates of warming has been observed in the Arctic, where temperatures have risen by 0.6 degrees Celsius every decade since 1978. In Antarctica, however, the increase is just 0.1 degrees Celsius, despite similar levels of atmospheric CO2 in both polar regions. The reason for the difference may be that fossil fuels are extracted in the Arctic, but not in the Antarctic. From 2007, more than 400 oil and gas fields have been developed north of the Arctic Circle. while in Antarctica, fossil fuel extraction is banned. ECMC, ECMC partners with CDPHE, APCD, etc. for data for cumulative impacts. Similarly, can ECMC partner with county or city land use department, then mandate the oil and gas industry to plant trees on the periphery of the oil fields? Topsoil is degraded in the site of oil fields. Planting trees in the periphery can help a little bit. And it also improves the topography appeal or the visual appeal, and also tourism industry would benefit. Please make this happen. And if you say that you cannot control the individual people to plant trees within their boundaries, then at least please enforce this when you approve CFPs or big oil fields. 3, can the ECMC collaborate with Metro Water Recovery or Denver Water to get waste like non-potable water and use that for fracking? 4, deep in the ground steel casings are eroding and contaminating groundwater. This also has to be accounted for in the cumulative impacts. Groundwater contamination is tricky to identify as water moves very slowly. 5, existing area infrastructure must be considered for the cumulative impacts, like number of roads, traffic, pollution, etc. And 6, cumulative impacts must consider the geography of the region, whether there are any water bodies like ponds, ditches, wetlands, gulches, streams, rivers, etc. And rules must be formulated and implemented to preserve these ponds, gulches, wetlands, ditches, etc. These may be small, but are an important integral part of the wildlife and ecosystem. The ditches and small ponds actually act as carbon sinks. Nowadays, I've seen that these are sealed off with mud and dirt when any construction or expansion takes place for oil and gas. Thank you.
Thank you very much for appearing with us this morning and taking time out of your day. We do appreciate your comments. Does any commissioner have questions? Great. Well, listen, we really appreciate it. I know that Commissioner McGowan is going to speak with you about being a party in the cumulative impacts rulemaking. So she'll reach out. I think you guys have already had one discussion. We appreciate it. We look forward to having you present to us more as we move into the rules. At this point, we're in the process of creating straw dog rules. Once those get published, then we'll start in on party status. So thanks very much for being with us.
Yeah, thank you.
All right. With that, we've finalized public comment. We didn't have anybody else sign up. Next on our agenda is a consent agenda. Does any commissioner have questions with regard to consent? Seeing none, do we have a motion to approve consent?
So moved.
Second.
Motion and a second to approve consent. All those in favor signify by saying aye.
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 The matters on the consent agenda are approved. We have 2 oil and gas development plans this morning. The first is docket 230500187. This is an oil and gas development plan. The applicant is Noble Energy. Let's bring the attorneys and the witnesses to the table. I've kind of been enjoying these really short breaks as we do that. So let's return in about 3 minutes and have everybody up and running at that point in time. All right, we are back. I do note that we have Mr. Andrews with us, so I anticipate he would like to lead off. If that's the case, Mr. Andrews, you're recognized.
Thank you, Chair Robbins. This is in regards to Noble Energy's DP 455 OGDP that's about to be heard. The first paragraph on page 6 of the director's recommendation indicates there are no residential building units within 1 mile of both proposed locations. This is not accurate. While the proposed YY18-7 location is greater than 1 mile from the nearest residential building unit, the proposed Y12-15 location is approximately 3,259 feet from the nearest residential building unit. This clarification does not change our recommendation of approval for this OGDP. Thank you.
Thank you very much. Any questions for Mr. Andrews? Great. Thank you very much. Thanks for being here. Thanks for making the clarification. Get it. We now will move to hear from Jason Maxey, the Director and the Local Government Designee of the Weld County Oil and Gas Energy Department. Mr. Maxey.
Good morning, Chair, and good morning, Commissioners and staff. Thank you again, as always, for the opportunity to speak for a few minutes regarding the Weld County process for these locations in front of you today for review and consideration. As Mr. Andrews says, and as the agenda mentions, this is for Noble's DP 455 OGDP, which is in front of you now. And for Weld County, these came in as two separate WOGLA applications under the YY18-07 and Y12-15 names. We held our pre-application meeting for these two well pad only locations on December 21st of 2022. The attendees at that meeting included not only Noble staff and Weld County staff, but also the town of Kingsburg, ECMC, CDPHE, and CPW. So there was a lot of attendees at that meeting. Went very well. The two 1041 WOGLA applications were received August 21st of 2023. Throughout our process, the notice as well as the application process, Weld County did not receive any public comments about either one of these locations. We did not receive any applications to participate in our hearing either. We held our hearing on November 9th, 2023. So just last week, actually, so very recently. The hearing officer considered testimony at the hearing from both staff and the applicant, and the applications were both approved. Now, the final order for these have not been issued yet. This one kind of came to you all a little bit quicker than us getting out the final order. However, the final order will be issued soon and will be recorded as per our process with the Weld County Clerk and Recorder, and then will subsequently be noticed in the Greeley Tribune for that legal notification requirement. We did submit 2A comments to you all on October 13th of 2023, and they should be included in the director's recommendation. Weld County, I just want to say, I heard Mr. Andrews I guess, comments there at the very beginning about the distance. And I acknowledge those, and I also just want to echo the fact that we don't have any questions or clarifications about that. We also found that there was no building units within the 1041 WOGLA zone, which of course is our primary point of consideration, and well beyond that. Even though it might not be a mile, it's well beyond the 2,000 feet WOGLA zone. So therefore, with those comments being made, Chair, I would just say that Weld County does agree with the director's recommendation as slightly corrected from Mr. Andrews, and we would support your consideration and approval of this OGDP. Thank you very much, and as always, available for comments.
Thank you very much, Mr. Maxey. We appreciate the information from the relevant local government. It's very important to our decision-making process, as you're aware. So thanks for being with us. Does anyone have questions of Mr. Maxey? All right, seeing none, we know how to reach you if we need to, but thanks again.
Thank you.
Ms. Linky.
Good morning. We have our panel here, and if it works, we can swear everyone in before we share our PowerPoint.
Yep, that'd be the order of the call. So if all the witnesses could daylight themselves visually, we've got Attorney General Mercer ready to do some swearings.
Good morning, everyone. So what we'll do is I'll go one by one in the order I see you on my screen and ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll start with Mr. Dennison.
Doug Dennison, I swear to tell the truth.
Thank you. Mr. Dinkle? Oh, you're on mute.
Michael Dinkle, I swear to tell the truth.
Thank you. Mr. Antonio?
Brian Antonio, I swear to tell the truth.
Thank you. Mr. Rouse?
Jim Rouse, I swear to tell the truth.
Thank you. And finally, Mr. Keller.
Michael Keller, I swear to tell the truth.
Thank you all.
Wonderful.
All right.
Thank you.
You are recognized, Ms. Wazalinki, for your presentation.
Thank you. We'll just get our PowerPoint up and I will get started. Great. I think we just need that in presentation mode. Perfect. Okay. Well, good morning, commissioners. Again, my name is Kelsey Wazalinki with Jost Energy Law. And with Jamie Jost, we represent Noble Energy in the DP 455 OGDP before you today in docket 2305-00187. We would like to thank Mr. Maxey and Weld County for their efforts in support of the DP 455 OGDP through the WOGLA process, and also ECMC staff and the director for their efforts on this OGDP. Next slide. The DP 455 OGDP requests that the Commission establish a 2,263.57 acre drilling and spacing unit to develop 16 new horizontal wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. The DP 455 OGDP also requests that the Commission approve a 2,263.57 acre OGDP with 2 new Form 2As for the Y12-15 location and the YY1807 location for the development of a total of 16 new horizontal wells. Like the DP 452 OGDP that you approved last month, the DP 455 OGDP includes a variance request for relief from the soil removal and segregation requirements in Rule 1002B2 and the restoration and revegetation requirements in Rule 1003E2 for the Y1215 pad and the YY1807 pad, which we will review in detail today. And as indicated by Mr. Maxey, the 2 DP 455 locations are within Weld County, and the WOGLAs were approved on November 9th. The proximate local government is the town of Keensburg, and Noble will describe the consultation and coordination with that proximate local government in the presentation today. This OGDP does not trigger any Rule 304 ALA criteria, and Noble has complied with all notice requirements, no formal petitions were filed, and no public comments were submitted on the Form 2As. Next slide. This slide provides an overview of the Y12-15 location. As I mentioned, this location does not trigger any ALA criteria. It is over 3,000 feet from the nearest RBU, and the WOGLA was approved on November 9th. The location is within a disproportionately impacted community under the new statutory definition. Noble consulted with CDPHE and agreed to 33 CDPHE recommended BMPs. The location will not have any impacts to floodplains or wetlands. Next slide. This slide provides an overview of the second proposed location, the YY1807. This location also does not trigger any ALA criteria. It is over 1 mile from the nearest RBU, and the WOGLA was approved on November 9th. The location is also within a disproportionately impacted community under the new statutory definition. And again, Noble agreed to 33 CDPHE recommended BMPs. And this location will also not have any impacts to floodplains or wetlands. Next slide. This slide shows the proposed wellbore laterals in the proposed 2,263 acre drilling and spacing unit. 8 wells will be drilled from the Y1215 pad and 8 from the YY1807 pad, targeting fee minerals. I'll now turn the presentation over to Doug Dennison to further describe the proposed operations.
Good morning, Commissioners. Doug Dennison, Senior Permitting Coordinator with Noble Chevron. This slide just is a quick synopsis of our current scheduled plan for developing this OGDP, with the current plan to begin activity sometime mid-year next year. Next slide, please. As Kelsey indicated, the town of Keensburg is approximate local government for this OGDP. For the YY1807 pad, which is within 2,000 feet of the town's municipal boundary, Mr. Maxey did indicate that the town of Keensburg participated in Weld County's pre-app process, but we also entered into formal consultation with the town of Keensburg beginning in April of this year. through that consultation, the town identified that the access roads that we intend to use to access these locations have been or will be annexed by the town of Keensburg. And so we have started the process of entering into a road maintenance agreement with the town. In the event that certain sections are not annexed by the town by the time we begin work on this OGDP, we will also enter into a road maintenance agreement with Weld County for those sections of the road. The town also identified that there's an RV park a little over a mile to the southwest of the YY 1807 pad. And if you look at the map on the right, that RV park is in that area outlined in purple to the right and below of the 24 in the center of section 24. And they just asked that we consider noise and light impacts to that RV park. We had already planned to install a sound wall on the south and east sides of the YY 1807 pad, primarily initially for light mitigation for vehicles traveling on Interstate 76, but that sound wall will also provide some additional light and noise mitigation for that RV park. The other good news on this project is both County Road 18 and County Road 59 that will be used as the haul route for this OGDP. Both of those roads are paved. Next slide, please. As Kelsey indicated, through the new statutory definition of DI community, these two locations are in a DI community. So we consulted with CDPHE in October of this year, committed to 33 of CDPHE's BMPs. At the time we entered into this consultation, we did not think we would have line power available for drilling, but we have since found that it's highly likely that the utility will be able to provide line power. Just based on our recent experience with utilities, we have little control over those third parties and their ability to deliver the electricity. So we would like to retain the optionality that the current BMP provides, that if the grid power is not available, we'd either use a natural gas or dual fuel powered drilling rig. Our Form 2B for this OGDP did assume dual fuel. And I'll talk a bit more about providing a Form 4 at a later date if we're able to electrify this rig as planned, that we would update our 2B emissions estimates. Our hydraulic fracturing strings are all 100% Tier 4 engines, and currently our contractors that provide non-road construction equipment and service fleet services to us are currently at about 75% Tier 4. Next slide, please. These next few slides are just a list of some of the BMPs that we will utilize to avoid, minimize, and mitigate our impacts from development of this OGDP. This isn't an all-inclusive list, just a few highlights. And I'll talk more about this first bullet in a few minutes, but we are going to send the production from the wells on these well pads to an existing facility. That facility is in the process of being converted from a tanked facility to a tankless, which will significantly reduce emissions from production activities. These well pads and that facility are all serviced by oil, gas, and water takeaway pipelines. We will also pipe fresh water to these locations for completions activities via temporary surface lines. I mentioned that we plan to electrify the drilling operations, and this production facility is also electrified. We'll use Group 3 drilling fluids, and then we'll implement a number of BMPs on site during drilling to manage the drilling fluids and the cuttings to minimize odor and air emissions from those operations. We'll implement a number of BMPs related to dust mitigation. We do automate all of our new wells and production facilities, which again minimizes the truck traffic. And I'll also talk about here in a few minutes our air monitoring program that will be implemented. Next slide, please. For light and noise, I mentioned that our plan is to install a sound wall on the south and east sides of the YY 1807 pad. Primarily that was designed for light mitigation for traffic on I-76, but will also provide light and noise mitigation for the RV park that the town of Keansburg mentioned. There will be no permanent lighting on these well pads once the wells go in production. We'll utilize our quiet frac fleet for completions. As I mentioned, we will use pipeline takeaway for these locations, which will eliminate much of the truck traffic. And in the event that we do need artificial lift on these wells at some point, we will utilize gas lift and less obtrusive artificial lift technologies. Next, please. In regard to water, land, and site safety, our tankless approach and our use of pipelines significantly reduces the potential for spills and leaks during production activities. Both of these sites have engineered drainage designs that have been approved by Weld County. There are no public water systems nearby. We will not have any chemical storage, refueling, or staging within 500 feet of an ordinary high water mark. We'll implement a number of inspection techniques to quickly catch spills, leaks, and other issues. These wells and the production facility will be monitored 24/7 from our operations center in our Greeley office. And that monitoring allows us to quickly and remotely shut in activities if there's an issue identified. And during our drilling and completion operations, we will have a guard shack at the entrance of the lease access road to control access to the locations. Next, please. You've seen this slide several times from us in our presentations, but again, just a summary of the continuous air monitoring program that will be implemented at both of these locations. And we will submit an air quality monitoring plan to CDPHE for review and approval prior to implementation. Next slide, please. Just wanted to wrap up my portion of the presentation with a discussion of a few of the beneficial impacts that will occur related to this OGDP development. Consistent with what you've seen from us in other developments, we continue to look for ways to consolidate our operations into the lowest number of locations possible. Our original plan for this OGDP contemplated 3 well pads and 1 multi, and a multi is a combination well pad and production facility. Those are shown by the yellow squares in the figure to the right. As you know, our proposed development now is for 2 well pads, and then we are proposing to produce to an existing production facility, the Y1128 multi, that's shown to the northwest on the map to the right. This consolidation has significantly reduced both the initial and long-term disturbance associated with this development. As I mentioned, that existing facility will be converted from a tanked facility to tankless and is electrified. These well pads happen to be in an area where there's very little legacy well development, particularly legacy vertical wells. So at this time, we only have 1 well, the Kinga State well shown at the top of the map, that's been identified that needs to be P&A'd as part of this development. That will return approximately 2 acres of land once reclaimed. And consistent with our other recent OGDPs, we're committed to providing a Form 4 sundry prior to completion activities to finalize the list of wells to be P&A'd and a proposed schedule, but also to provide an update to the 2B if we are able to convert the drilling rig to line power. And then we'll also provide emission reductions from P&A activities, and then also emission reductions related to upgrading that existing production facility. So I'll pass the presentation back to Kelsey. Thank you.
Thank you, Doug. So part of the DP 455 OGDP application includes a request for a variance from the soil removal and segregation requirements in Rule 1002B2 and the restoration and revegetation requirements in Rule 1003E2 for the Y1215 pad and the YY1807 pad. Like the DP 452 OGDP, which you approved in October, the surface owner for these 2 locations is the Gutterson Ranch, and Gutterson and Noble have entered into an alternative reclamation plan for these locations, which provides that the surface soils not be segregated and that Noble will import soil approved by the surface owner to enhance the effectiveness of future reclamation of these locations. In support of the variance application, Michael Dinkle, who's a senior environmental scientist for Quandary Consultants, provided testimony regarding the 5 elements of Rule 502C. And Mr. Dinkle is at the hearing today and is available to answer any questions regarding his testimony. Next slide. So following the DP 452 OGDP hearing, Noble provided additional clarity regarding the topsoil variance request and Noble's commitments to ECMC staff. These commitments are outlined on this slide. During construction operations for both locations, a clay layer will be imported for the subgrade layer underneath the road base or final grade to help stabilize the working pad surface. Depending on slopes, the same clay can be used to help stabilize them during construction. It can give the seed, straw mulch, and hydro mulch something to bind to. Noble will have stockpiles imported during interim reclamation to be used for final reclamation for both locations, which is consistent with Noble's reclamation practices off of the Gutterson Ranch. And it's important to note that the end result of interim and final reclamation at the Y1215 pad and the YY1807 pad will meet the intent and requirements of the ECMC 1000 series rules. Noble will comply with Rule 1003E2 to complete interim reclamation by ensuring that all disturbed areas have been stabilized in such a way as to minimize erosion to the extent practicable, or a uniform vegetative cover has been established that reflects pre-disturbance or reference area forbs, shrubs, and grasses with total percent plant cover of at least 80% of pre-disturbance levels or reference areas, excluding noxious weeds. Next slide. This slide highlights the supporting evidence for the 5 elements in Rule 502C. As shown in the variance application, testimony, and exhibits, Noble meets these 5 elements and has support from the surface owner for the alternative reclamation plan. Noble will implement protective BMPs at the locations related to reclamation and stormwater management and has proven successful reclamation with this method at other locations in the area. As indicated in the director recommendation, the director and ECMC staff support the variance request. Next slide. To summarize the requested variance in Mr. Dinkle's testimony, the nature of the soil on the Gutterson Ranch is such that topsoil removal will cause more damage to the locations compared to leaving the topsoil in place. Mr. Dinkle's testimony shows that the requested alternative reclamation plan is in fact more protective of the local environment than the standards set forth in Rules 1002B2 and 1003E2. Other locations on the Gutterson Ranch have achieved successful interim reclamation after recontouring an amendment addition with a custom sandy loam mix. This is shown on the photo on this slide. And for these reasons, Noble respectfully requests that the Commission grant Noble a variance from Rules 1002B2 and 1003E2 for the Y1215 pad and the YY1807 pad in accordance with the alternative reclamation plan and as part of the DP 455 OGDP. Next slide. To summarize the DP 455 OGDP, I'll note just a few highlights. The proposed Y1215 pad and YY1807 pad are sited outside of all sensitive receptors and do not trigger any ALA criteria, thereby avoiding potential adverse impacts. The BMPs on the Form 2As further avoid, minimize, and mitigate potential adverse impacts. Weld County approved the 1041 WOGLAs on November 9th, 2023, and the director determined that the DP 455 OGDP complies with the Commission's rules and recommends approval. Next slide. This slide shows the relief requested for the DP 455 OGDP, including the requested variance. And this does conclude our presentation. So I will have the Noble team please stop the screen share and we can turn our cameras on and we are open for any questions you have.
Thank you, Ms. Wazelinski, for the presentation. Thanks to the panel. Thanks to the work of our staff. At this time, the panel is open for questions from commissioners. Commissioner McGowan.
Thank you, Mr. Chair, and thanks for the presentation. I think this is another application that's been put together well. I'm just curious to know why electrification is one option, working on that, but then the backup is dual fuel, which seems kind of like maybe the lowest tier that we could choose versus some other options that maybe are out there. I'm wondering if you all could talk about why you're going with dual fuel.
Thanks, Commissioner. I can start to address that question, but we'll ask others from our team to weigh in also. We currently have one dual fuel and one natural gas rig in our rig fleet. So that's based on what we currently have available. I know our drilling team is looking at other options. You know, I know the natural battery or the natural gas with battery assist is becoming more prevalent. So, you know, I think over time you will see a shift in what we have available to power our rigs, but currently the two rigs we have in our fleet are either a dual fuel or natural gas. So our commitment right now is based on what we have available.
Okay, thanks for the feedback. As you know, like I think we're really trying to figure out how we reduce those emissions in the non-attainment area. So I'm looking forward to you all getting updated technology, but I appreciate the response. Thank you.
Other questions from commissioners or the panel? Okay, seeing no further questions, the next step would be deliberations. Anyone care to start deliberations? Commissioner Cross.
Thank you, Mr. Chair. Seeing that there's not a lot of deliberations here, I do think that this is a protective, application. It obviously has a lot of the same circumstances we reviewed in the last DP. It was a 452 that Chevron brought forward, and as with that one, I think that this does set forth a lot of BMPs that are necessary to protect welfare, safety, environment, wildlife resources, etc. And so with that, I'd move to approve the application and the variance for the reclamation.
We have deliberations and a motion. Do we have a second on the motion?
I'll second.
Motion and a second. Further discussion on the motion. Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you very much, Ms. Wazelinski. Thanks to the panel. Thanks to our staff for assisting the applicant and putting together a good application that has been approved.
Thank you.
All right, we've got another OGDP up next. It's going to take a little bit of time to get all the relevant parties involved. We've got a couple of folks that have petitioned. Let's take 10 minutes and return at 9:51, at which time I would hope to see all of the relevant parties for the docket ending in 0275 ready to go. See you at 9:51. All right, welcome back, commissioners. For the record, it is Wednesday, November 15th. It is 9:52, and we are taking up our next docket. The docket number is 221-000-275. This is an oil and gas development plan. The applicant is Gunnison Energy. We have a couple of petitioners in this matter as well. Would like to start with entries of appearance on behalf of the various parties. Mr. McGowan, you're muted.
Good morning. Can you hear me?
Yes, we can hear you now.
All right. Sorry about that, Mr. Chairman. Good morning. Chris McGowan on behalf of the applicant Gunnison Energy.
Mr. Foote?
Yes, good morning, Mr. Chair and Commissioners. Michael Foote on behalf of Citizens for a Healthy Community, or CHC.
Okay. Do we have anyone else that is representing a party here? I'm seeing a phone number, 7688.
Your Honor, Mr. Chair, that's my number. I'm having a little audio difficulty, so I'm calling in today. So I'm doing the audio via my phone.
Oh, okay. All right, great. I just like to make sure I know everyone that is with us. Mr. Navabian, I'm sorry, I don't know how to pronounce your name. Are you here as a attorney?
No, sir. I am the president of Gunnison Energy.
Okay. You might want to unvisualize for just a bit. We've got some procedural matters to take care of first.
Sure.
Okay. Ms. Mercer, did you have something to weigh in?
So thank you, Mr. Chair. I was just going to clarify that the only represented parties should be Gunnison and CHC.
Right. Okay. Thank you very much. I'm stumbling through this morning. I think I'll be doing this better since we've had a couple of hearings this week. Okay. I think to start, Mr. McGowan and Mr. Foote, the first issue is whether the commission should grant petitioner Citizens for a Healthy Community affected person status for purposes of participating in the OGDP hearing pursuant to Rule 507A. I know you have briefed that. We've read the written briefs. I am inclined to grant a few minutes of argument on that point to each side. So if you want to do that, Mr. Foote, I would allow to hear from you first.
Yes, I'd be happy to. Thank you, Mr. Chair and Commissioners. And I'll just give a very brief summary of our argument because you've already read it, but would also ask for just a minute or two to respond to Mr. McGowan's reply, since I haven't had a chance to do that, if there's any arguments there that need to be responded to. But just to make it clear, we are working off an amended petition that the CHC filed pursuant to the deadline. And the amended petition, among other things, does talk about the two member organizations, the Valley Organic Growers Association and the Terra Ditch and Reservoir Company, that are uniquely positioned and unique parties in this matter. And we believe clearly would fall under an affected person status had they decided to petition in and of themselves, but they had decided to work with the CHC in order to help their advocacy in this matter. And case law is clear that CHC can appear if it has members like Terra Ditch and like Voga as affected persons. And so in this case, again, we believe it's clear that CHC and its members can be affected persons. We are uniquely positioned to petition about this matter, to raise concerns about the matter. It's clear from the commission's rules as well as the mission statement, deliberations, and SBP that there is a dividing line here between those that may want to be affected persons in a proceeding. On the one hand, you have folks or groups that would say have effects held in common. That would refer to people that are concerned about ozone but don't live in the immediate area, or about climate considerations but again don't live in the immediate area. And then there's those, and the dividing line applies to those that have unique impacts. And this instance is clearly on the side of unique impacts. Voga is a local organization. They represent several organic farmers in the area. Terra Ditch and Reservoir Company, again, is hyper-local. It has one interest, and that's its ditch and reservoir that serves a number of local residents in the area. They're within a few miles of this proposed expansion of the location. And it's clearly different than, say, somebody in Arapahoe County that wants to petition as an affected person on a Weld County OGDP because they have concerns about ozone non-attainment, or someone in Jeffco that would want to petition as an affected person in this case because they're concerned about the climate. They're just two different things. It's very local here. It's very unique. And just going through very quickly the Rule 507A4 requirements for analysis. Number one on 507A4 requires the commission to analyze whether the interest claimed is one protected or adversely affected by the application. And here it should be clear that one of the interests that we're focused on, there are several, but one is the protection of water supplies, and the protection of water supplies to residents in the area and to members of Voga, members of the Terra Ditch and Reservoir Company. 507A4B asked for an analysis about whether a reasonable relationship exists between the interest claimed and the activity regulated. And it's clear that oil and gas operations could adversely affect water supplies. There's several rules that the ECMC has to protect against those things. And the water supplies in this case are close. They're within a couple of 100 feet from the location. And as I said, many of the members are just a couple of miles away downstream from any kind of potential contamination event. 507A4C requires an analysis of the likely impacts and magnitude of impacts of the regulated activity on health, safety, welfare, or use of property of the person. And as we mentioned in our petition and in our pre-hearing statement, those interests could be significantly and adversely affected if there is water contamination or seismic activity here. Really big effects if those types of things happen. Subsection D requires an analysis of likely impacts of the regulated activity on the impacted natural resources or wildlife used or enjoyed by the person. Again, that's really the same type of answer as subsection C for us. These types of the water issues could be significantly impacted. Water rights could be significantly impacted if there is a negative and adverse type of impact here, particularly geological hazards or water contamination. And the rest, subsection E, is not applicable here because neither of these organizations are local government. So the bottom line here, again, I'll just restate, is that what we've alleged in the petition are unique to this particular application. It's not talking about effects that would be held in common as those that would be concerned about ozone non-attainment or climate. It's unique, it's local, and we would ask the commission to grant our affected person status so we can make the case in front of the commission.
Okay, thank you, Mr. Foote, for the argument there, the resummary of it. Mr. McCowan, did you want to weigh in?
Yes, Mr. Chairman. So we'll start out. Our objection starts with Rule 512C, which provides that parties to a proceeding may not provide public comment in that proceeding. They are not considered part of the public for common purposes. As has been acknowledged by CHC, the initial petition deadline in this matter was May of 2023. CHC filed its first petition for party status on May 8th, pursuant to Rule 507. CHC, by its own admission, is a group formed to oppose oil and gas development, is a regular participant in commission proceedings, and was represented by counsel at the time of its petition. However, during that interim time period, on May 12th, CHC, TDRC, and VOGA submitted numerous public comments. At the time, CHC was the petitioner, and TDRC and VOGA had not yet asserted their status as parties. In other words, CHC, as a sophisticated party represented by counsel, submitted public comments while knowingly petitioning as a party in the matter. We believe this to be a knowing violation of Rule 512. CHC argues that it had not been granted party status when it made its public comment. Assuming that argument is true, the CHC should not be admitted as a party. It knowingly, while represented, had a pending application for party status and yet still submitted numerous public comments. That is certainly their right, and we do not oppose that action in any way. However, by taking advantage of that window, subsequently allowing CHC to be granted party status would violate both the spirit and letter of Rule 512. In other words, we believe CHC had a choice. It could either pursue party status or make public comments as is stated in the rule. It chose the latter. We ask the commission to respect that conscious decision and deny party status. To articulate the issue more clearly, in CHC's exhibit, there is an email from Ms. Ledger, director of CHC, that on May 10th, after they submitted petition for party status, specifically asking the hearing officer about the public comment deadline, clearly anticipating that it would participate in public comment despite its submission of an application for party status, clearly illustrating CHC had an intention to pursue both party status and simultaneously submitting public comments and direct contravention of the rules. Further, we would note the ability for the public to comment allowed them the opportunity to participate in this permit and make their position already known. Gunnison spent considerable time and effort in responding to the concerns raised in their public comment, ensuring that CHC has been adequately represented in the matter via the Rule 512 comment process. Subsequently, at the request of ECMC, Gunnison renoticed its permit, allowing CHC to, as Mr. Foote said, attempt to amend its application for party status to cure the serious deficiencies in its initial petition. To cure those deficiencies, CHC did attempt to add Terra Ditch Reservoir Company and Valley Organic Growers Association as affected parties. However, as established by the timeline provided in CHC's pre-hearing statement, when the amended petition was filed on June 12th, CHC added 2 parties that it knew had already made public comment, again in direct violation of Rule 512. In other words, to cure the deficiencies in its initial petition, CHC brought in 2 parties that it could not add as they had already made public comment. Therefore, either the commission will grant party status to an entity that knowingly violated the rules, or the 2 parties that were added must be struck, leaving CHC with its initial amended petition. In either case, CHC should be denied party status. Allowing CHC to file party status, make public comments, then file party status again with 2 entities that has direct knowledge have already made public comments would violate the tenets and specific language contained in Rule 512C. As the statement of basis and purpose provided, parties may not use the public process to provide additional testimony. Simply put, no matter how you look at this situation, CHC, TDRC, and VOGA are attempting to subvert the rules and gain 2 bites at the apple. In assuming the initial petition stands, CHC did attempt to cure its deficient original petition with 2 parties that had already commented. This leaves CHC's original petition for party status as its only valid petition. As we have previously argued, having an interest in litigation neither grants a party an interest nor bestows them with an appropriate arm necessary to grant them party status. As we outlined in our pre-hearing statement, CHC's interest does not rise to the standards outlined in Rule 507, and therefore CHC should be denied party status in this matter based on that deficient petition and subsequent failure to cure that deficiency by adding entities that had previously submitted public comment and therefore were not able to be added parties at the time of their amended petition. The amended petition on June 12th sought to add TDRC and VOCA as parties. Despite the assertion the June 12 petition is also deficient, it does not rise to the standard articulated in Rule 507. TDRC, for example, alleges that it's a water company that manages water for 50 farms. In other words, that a water company that provides water to customers, but does not allege its harm is rooted in the Terra Creek Dam, but alleges its harm is rooted in Terra Creek Dam being a Class 1 hazardous dam and Terra Canyon having a precarious hillside within the Terra Canyon. Rule 507A, as Mr. Foote noted, provides that for standing, a party must illustrate the following: identify the interest in the activity adversely affected, allege that interest could be an injury in fact if the application is granted, and demonstrate that the injury alleged is not common to members of the general public. TDRC alleges it has an interest in this activity, i.e. the oil and gas permit, because even though it is located over 3 miles from the west edge of the pad, and they acknowledge the wells do not go under the Terra ditch, it is, quote, well known that hydraulic fracturing induces seismicity that can travel for miles. That was not supported by any evidence, statements, or otherwise any substantial substantive evidence at all. Per Colorado law, although both tangible injuries, physical damage, and intangible injuries can satisfy the injury in fact requirement for standing, an injury that is overly indirect and incidental to the defendant's action will not convey standing, nor will the remote possibility of a future injury. That is precisely the situation we have here. Terra Creek has simply alleged that some speculative injury may happen in the future. No data, no scientific proof, or any substantive evidence was submitted with the allegation to support that statement. In other words, alleging a seismic event may happen miles away from activity that has proven not to cause seismic activities, and arguing that it may travel for miles and possibly impact something is so speculative, it does not satisfy the tenets set forth in Rule 507A, claiming injury, which is a remote possibility of a future injury, and it's direct and incidental, and it cannot confer standing. As such, TDRC's alleged injury is speculative, remote, and unsupported by an evidence or substantial information outside their statement in the petition. Furthermore, the injury alleged by definition would be to the public at large. Indeed, Colorado law requires an injury must be sufficiently direct and palpable. In other words, the argument here is that it has a unique duty to deliver water, but failed to note who else might be able to access that water, or that it's alleging it's in charge of. Stated another way, they are arguing since their business model is to deliver water, they have a unique injury that is not common to the public. However, that's not the standard. The standard is the injury must not be common to the members of the public, which would be the case if a water source would allegedly be impacted. Similarly, VOGA's addition as a party status has similar issues that do not cure CHC's deficient petition for party status. VOGA is an association that represents members who live and work in the North Fork Valley. VOGA alleges its interest in activity is because VOGA has an interest in ensuring the water supply of its members remains uncontaminated by oil and gas, and it has a, quote, duty to maintain the reputation of clean water as its members. We do not dispute Mr. Foote's contention that associations may be admitted as a party to a proceeding in certain instances. However, as was the case with CHC's petition and the previous party, Voga alleged injuries, in fact, that were actually more of a speculative injury, and possible that it is indirect and incidental to the defendant's conduct. Voga's first claim is economic harm by contamination of water, but it does not specify any member that would be injured. More importantly, it does not demonstrate or allege how the water supply could be impacted. While it does make general allegations that its members' irrigation water comes from the North Fork of the Gunnison River, fed by tributaries, and these could possibly be injured, and it should be noted the petition does not allege how that injury would happen. This claim is mere speculative injury that is overly indirect and incidental to the defendant's action that does not convey standing. Indeed, Colorado law is clear. The remote possibility of a future injury is not enough to convey party standing. This is further true with its second claim. The mere perception of oil and gas in its water supply would cause economic harm. Again, as we noted previously, the remote possibility of a future injury does not convey appropriate harm to convey party status. In order to have an interest that is protected, it must be concrete and particularized and actual or imminent, as opposed to conjectural or hypothetical. That is, by the petitioner's own admittance, the case here. Voga's claim is that if oil and gas development happens, their alleged member's reputation might be harmed in a general manner, causing some sort of economic harm. To state it another way, Voga's claims are simply that if oil and gas development were to occur, their members, their speculation of a remote possibility of future injury to their reputations. In other words, it is reasonable to think that Voga, much like CHC, is an organization with a general interest in a problem, and that alleged injury, in fact, is indirect and incidental to the defendant's action. In sum, CHE, Voga, and TDRC have each alleged injuries that are overly speculative in nature based on remote possibilities of future injuries. As the claims by the parties indirect and incidental and not supported by evidence, standing should not be conferred. Finally, CHC relies heavily on ECMC Rule 507A4, which allows the Commission to consider some additional factors in making a determination for party status. It should be noted that if CHC's petition does not satisfy the previously outlined 507A3, we would argue the provisions in A4 are not at issue here. However, we would also like to address those elements contained in A4. As noted above, each of the interests claimed by all three alleged parties are speculative in nature, ancillary to the permanent issue, and not directly attributable to the oil and gas development. In other words, each alleged interest is a remote possibility of a future injury, not one that is concrete or particularized, actual or imminent. Interests claimed are those of a general nature applicable to concerns surrounding oil and gas development. As the Commission saw in both the original and amended petitions, each of the proposed parties' interests are couched in terms that show harm alleged may happen in the future if some possibility arises. And some assumption of extraordinary events that have never previously happened is not enough to show a reasonable relationship between the interest claimed and the activity regulated, which here is oil and gas. And again, as admitted by the participants, there is no substantive evidence that any of the possible issues have ever happened or will happen in the future. Further, if they were to happen, CHC, Voga, and TDRC have shown nothing more than a remote possibility that those future incidents would affect their interests. To quote CHC, their interest would be materially affected if something goes wrong. This illustrates CHC's petition is based on a mere interest in a problem, which does not convey standing, as opposed to an organization which members are directly injured. Therefore, we believe you should deny them standing.
All right. Commissioners, we've now heard from the parties. I'm going to summarize my thoughts on this. I think generally speaking, as chair, I rule on motions, but I would like input from you guys and girls if you think that I've not got this right. I'm looking at the arguments with regard to standing. CHC argues it has standing because two of its members, the Terra Ditch Company and Valley Organic Growers Association, will be affected or aggrieved by the permit. Under Colorado law, an association has standing if one or more of its members would. So if either of these entities would qualify, CHC would qualify. In my opinion, the petition identified interest in the applications. The Ditch Company is concerned about the potential for induced seismicity from Gunnison's proposed operations, and Valley Organic Growers Association is concerned about water contamination from the operations. I believe these injuries could be, they've not been proven, injury in fact if the application is granted. They express both tangible damage to the ditch or dam, water contamination concerns, and intangible harm to reputation, harms that could arise related to the application. These injuries are specific to the members' livelihoods and are not common to the general public. I believe they satisfied the factors in 507A4 to grant the petition. I note the argument from Gunnison Energy that they also have provided public comment under 512C. I believe that the public comment was done at a time when CHC was not considered a petitioner, because we're making that determination today. I do agree with Gunnison Energy that CHC should not have two bites at the apple. I would move to strike the public written comments, but I would also allow CHC to go into detail relative to any comments that were made. You can remake those today in the hearing. So I would grant the petition, I would strike the written public comments, and I would seek to move forward with this application in that due course. Commissioners, does anybody have any concerns? Commissioner Cross?
Thank you, Mr. Chair. I agree with your proposed ruling. I think of particular note, as you said, I don't think that CHC was a party at the time that the comments were provided. Therefore, there's not any kind of argument, oral argument, written argument beyond what's proposed in the case management order. I think also it would be a lot different situation if they were using public comment now to provide new arguments that were provided in briefing, but it's not like any of the arguments being provided are going to be a surprise to Gunnison Energy or unique. It's something that they weren't able to prepare for. And therefore, I think that adds a little bit extra credence to what you were saying as well. So I would also agree. I think moving forward with striking the public comment before from CHC would be appropriate, and let them move forward with the briefing that was provided.
All right. Seeing no further additional comment, that'll be the ruling from the bench. The CHC is allowed in as a petitioner, and we will move forward in that regard. I'm looking at our order of play here. I know we've got comments from Delta County, and that's going to be next. I did want to, I'm not sure why it's in here, the determination if the commission has a conflict of interest. I'm not aware of any conflict of interest. If commissioners believe there's a conflict of interest, speak now or forever hold your peace. Seeing no speaking, you're holding your peace, and so we don't have any conflicts. I would next recognize whomever it is from Delta County to speak. And hearings manager Thomas, can you identify the appropriate individuals?
I did not hear of anyone from Delta County that wished to speak, but I do see someone raising their hand from the attendees list, a Wendell Kuntz. I don't know if that's related, so it's your decision if you want to elevate them or not. But I had not heard of anyone from Delta County wishing to speak as to open.
All right, well, why don't we, in all cautionary approach, elevate Mr. Kuntz and see what his question is. Yeah.
Wendell Kuntz is a commissioner from Delta County.
Well, then let's elevate him and let's hear from him, assuming he wants to speak. And thank you for the local government perspective there, Commissioner Messner. Mr. Kuntz, good morning.
Good morning, commissioners. Thank you for letting me in. I am Wendell Kuntz. I'm Delta County Commissioner. The proposed action by Gunnison Energy is in my district. Currently, I'm at the CWCB hearing with Director Gibbs and others, so excuse the short attendance here. I won't comment. I'm not a lawyer. I'm not going to comment on standing with either CHC or the other organizations, but I will speak on behalf of Gunnison Energy. They have been very, very good partners in the oil and gas development. They have been very conscientious about the work they do, very forthright on all of the work they have done, and have no reason to believe that the proposed action for the drilling would be of any detriment to Delta County or its citizens. And also, just for the record, I also chair the Gunnison Basin Roundtable, very concerned about waters. I do believe that the proposed action for drilling can be done in such a manner that it does protect the water rights and water quality of all those involved.
Thank you for the comments. Commissioner Kuntz, are you, just to make sure the record is clear, are you testifying individually or on behalf of the commission?
On behalf of Delta County, yes.
Okay, thank you very much. Give me just a sec. Let me see if anybody's got any questions for you before we let you back to the water conference.
Delta County's been very consistent about an all of the above energy strategy.
Excellent, thank you. Okay, I'm not seeing any questions. We'll let you get back to your regularly scheduled business, and thank you for attending this morning.
Thank you.
All right, looking back at our script, at this time, we've ruled on the party status, and so we are going to move into opening statements. We'll start with an opening statement from Gunnison Energy.
Good morning. Thank you, commissioners and Mr. Chair. I appreciate your time and appreciate your commitment to Colorado and your public service. We understand you have a difficult job, and we do appreciate the effort and time that each of you have put in to study our permit application, and all the materials submitted by my client, Gunnison Energy. Gunnison Energy is a Colorado company that is dedicated to the development of oil and gas resources in the most environmentally friendly manner possible. As you will see with our presentation today, Gunnison Energy has left no stone unturned with respect to this permit and the standards under which it will be developed. Gunnison Energy is a standard bearer in the oil and gas industry and takes pride in its reputation in both the oil and gas industry, but more importantly, in the communities that it operates, as you just heard. Today, you will see the effort that Gunnison Energy has put into ensure that all ECM standards were not only met, but in many and not most instances exceeded to the extent that they are technologically possible or feasible. Air, water, geohazards, spills, monitoring of location, drilling and operations, and more were all addressed in Gunnison's permit. Today, we will walk you through the permit, highlight each of the applicable standards, and how Gunnison will comply or exceed ECMC rules. Gunnison will discuss its location, its plans on how to use industry-leading technology for things like recycled water, how it chose to use existing locations in order to minimize service disturbances, and other efforts it undertook to ensure that the health, safety, and welfare of the public was taken into account every step of the way. We will also address the concerns raised by Citizens for a Healthy Community, the petitioner in this matter, and the public. I would note that Gunnison not only answered each of the public comments submitted, but also those concerns raised by the affected parties. Simply put, Gunnison has proposed what we believe to be one of the most advanced oil and gas permits in Colorado. So, in that vein, we would ask that you approve the application for Gunnison Energy for an order approving a 5,292 acre IPU lower 1291-13-24 oil and gas permit plan for the development of 6 horizontal wells with a surface location of the northeast-northwest of section 24 and southeast-southwest section of 13, township 12 south, range 91 west, 6 p.m. for the production operation of the Niobrara and Mancos formations, Peon's horizontal Niobrara field in Delta County, Colorado. As noted, Gunnison is a limited liability that is a registered operator in good standing with the commission and in compliance with all rules and regulations. We seek two oil and gas locations on the applicable lands, again, Township 12 South, Range 90 West, and Township 12 South, Range 91 West, sections 18, 19, and 30 of 12 South, Range 90, and sections 11, 12, 13, 14, 24, and 25 of Township 12 South, Range 91 West. The service location of the well pad for the IPU lower 1291-13-24 is in the northeast-northwest section of section 24, Township 12 South, Range 91 West, and it will be using the existing production facility at the Iron Point Unit Hotchkiss 1291-13-24 location ID 322013, and that's located at the southeast-southwest corner of section 13, Township 12 South, Range 91 West. The nearby crossroads are Gunnison County Road 1, CR1, and Gunnison County Road 265, County Road 265. Gunnison has otherwise met all application criteria, including notice and ownership of assignments, and it should be noted that these are in a federal exploratory unit, the Iron Point COC 074545X, and they are subject to all applicable Bureau of Land Management BLM rules, and each of the 6 proposed new wells from the IPU lower oil and gas location are subject to future BLM determinations. As noted, we provided all notice requirements, including notifying Delta County as the relevant local government and Gunnison County as the proximate local government. Again, we respectfully ask that you approve this permit, and we will turn the floor over to opening statement of the closing party.
All right, we now have an opening statement from Mr. Foote on behalf
Yes,
of.
yeah, thank you very much, Mr. Chair. Thank you, Commissioners. Again, Michael Foote representing Citizens for Healthy Community, or CHC, who are made up of about 500 individual and business members dedicated to protecting the North Fork Valley's air and water from the impacts of oil and gas development. CHC has focused much of its advocacy in front of this commission over the years in an effort to protect its community from off-site impacts of oil and gas operations. And it is in that context that the CHC approaches this OGDP application. What you're going to hear from us today is that this OGDP is not ready for approval. In contrast to what you just heard from the operator, there are plenty of stones unturned. The application doesn't give the commission a full picture of the risks, conduct meaningful risk analyses and mitigation, and is not responsive to community concerns, particularly when it comes to geological hazards and water contamination issues. Certainly, the applicant has submitted plenty of plans, but his plans have remained the same regardless of questions and community feedback. You can see that clearly in the director's recommendation, where the operator spends quite a bit of time talking about how what they are doing is just fine, no problems, but not any time making adjustments that would truly address community concerns. It sounds like that you'll hear the same thing today based on the operator's opening statement. Their response to community concerns has been that they've complied with the rules, they've checked the boxes, and so that's that. But getting approval from this commission requires more than just checking the boxes. It requires the operator to meet its burden to prove the application is protective of public health, safety, welfare of the environment, and wildlife. Any necessary and reasonable condition of approval is appropriate to assure impacts are avoided, and of course, if they can't be avoided, minimized and mitigated, regardless of the boxes that the operator has checked in its application. You'll hear from our witnesses that there are unique features of the North Fork Valley area that make it much riskier to put in new oil and gas operations. Those features make worst case scenarios like geological events or water contamination more likely. The operator has not considered those scenarios, not to mention make plans in case they did occur. Given those features and the risk, what we refer to in our pre-hearing statement, what we've asked the operator, and what we ask you today is why can't certain things be done in order to properly assure public health, safety, welfare of the environment and wildlife? For example, why can't the operator conduct an evidence-based, verifiable quantification of geohazard risks, which would include a landslide study to the west of the pad, and then implement BMPs or other protective measures recommended by that study? Why can't they disclose their spill prevention, control, and countermeasures plan to the ECMC with the CHC copied? Or why can't they report any spills they already have to report to the ECMC directly to representatives of those community organizations? There are other questions, and we'll get into those, but it seems like their answer to those questions may be they won't do those things because they don't have to. But as you'll hear today from CHC subject matter experts and local residents witnesses, this area is unique and poses unique challenges to oil and gas operations. It should be problematic to this commission that we don't have reasonable measures in place to keep what's special about the North Fork Valley intact, and that the operator won't really consider them. In addition, its application has a number of material inconsistencies, which also have not been addressed, which adds to the fact that the operator hasn't met its burden to gain commission approval of its application at this time. So we thank you for this opportunity to enter in as an affected person and advocate for the community members of the North Fork Valley. We have 4 witnesses lined up today that will speak to the points I've made in our opening. And if it's okay, I'll go ahead and conclude my opening statements here, but go into a quick roadmap of the witness testimony once we actually get to our presentation in chief.
Very good. And I would note to the parties that there are time allocations to the parties. 60 minutes is allotted to Gunnison Energy and 30 minutes is allotted to CHC. I do have my hearings manager, Mr. Thomas, taking time, tracking time for you guys. If you desire a understanding of the time allocations and what's left, just let me know. And with that, I think we will start with the case in chief by Gunnison Energy.
Sorry, I was on mute there. Just one quick clarification, Mr. Chair. It is our understanding that on the schedule, there is time for closing statements and some rebuttal, or do we need to reserve that now?
All of that is part of the full-on time that was allotted, so you can use your time however you like. The only
Okay.
thing that doesn't go against your time is going to be commissioner questions to your witnesses.
Okay, perfect. So we would like to reserve, let's say, reserve up to 15 minutes for our rebuttal, if that would be appropriate.
All right, Mr. Thomas, just let us know when they're closing in on 45 minutes in their case in chief, and then we can allow Mr. McGowan the opportunity to stop his case in chief and be ready for rebuttal.
Thank you, will do.
Thank you,
All
Mr.
right.
Chair, appreciate it. All right, so I'll have Ms. Donahue pull up the presentation. Hold on a second. Is the screen sharing on? I can't see. It's not coming up. There it is. Thank you. All right. Good afternoon, members of this commission. We appreciate your time. As we noted in our opening statement, this is the IPU lower OGDP the application on behalf of Gunnison Energy, hearing docket number 221-000-275. With us today is me, Chris McGowan. I'm counsel for the applicant. We have Ms. Jessica Donahue with Ardor Environmental, who will be presenting today. As you met earlier, Solar Nabavian, he's the president of Gunnison Energy and is a petroleum engineer with 22 years of diverse experience in unconventional and conventional assets. We have a Mr. Tyson Johnston. Mr. Johnston is the VP of Land and Regulatory for Gunnison Energy and has extensive background in oil and gas here in Colorado and elsewhere. We have Mr. Barrett Levine. Mr. Laverne is a professional engineer in the state of Colorado, as well as being a professional geologist pursuant to Colorado Revised Statute 23-41-208B, and I would note has extensive experience in the area, has worked in that section of the state since 2008, I believe, but he'll iterate more on that. We also have Ms. Martina Latasi, who is a licensed professional geologist in Wyoming and prepared the geologic hazard plan. Mr. Laverne and Ms. Latali are both available today to answer any questions related to the project geography or potential geologic hazards. We have Mr. Sean Higley, is a professional engineer in several Rocky Mountain states, including Colorado, as well as a professional hydrologist. Mr. Higley prepared the potential spill analysis that was included with the OGDP and is available today for questions as well. And Ms. Kelly Cox, who is a consultant with Quandary Consulting, specializing in air quality and compliance. She has over 16 years experience in that field. So we're going to move over. I'm going to move on to Ms. Donahue. She will start the presentation, and so I'll turn the floor over to her.
Mr. Chair, if I may.
Yeah, I'm sorry, AG Mercer, I forgot about the swearing ins of the witnesses. Mr. McGowan, can you visualize all your witnesses so we can get the witnesses sworn in?
Yes, Mr. Chair, I will get them. They should all be on. Give me 1 second. I'll yell at them. Give me 1 second.
Ms. Mercer, I do not see Sean Higley.
Thank you. I believe we're corralling everybody as we speak.
I believe everybody should be on in the office here. Thank you. So sorry about that, Ms. Mercer. My apologies.
Oh, that's okay. Thank you. All right. So members of the panel, welcome. I'll go one by one in the in the order I see you on my screen, and I'll just be asking you to raise your right hand, state your name, and that you swear to tell the truth. So I'll begin with Ms. Donahue.
Good morning, commissioners. My name is Jessica Donahue. I'm with Ardor Environmental, and I promise to tell the truth today.
Thank you. Mr. Nabavian.
My name is Solar Nabavian, and I swear to tell the truth.
Thank you, and apologies for mispronouncing your name. Mr. Johnston.
My name is Tyson Johnston, and I swear to tell the truth.
Thank you. Mr. Higley.
My name is Sean Higley, and I swear to tell the truth.
Thank you. Mr. Laverne?
My name is Barrett Laverne, and I swear to tell the truth.
Thank you. Ms. Cox?
My name is Kelly Cox, and I swear to tell the truth.
Thank you. Ms. Latasi, if you could turn on your camera, that would be appreciated.
Can you see me?
Yes, thank you.
Okay, great, thank you. Martina Latasi with Geosyn Consultants, and I swear to tell the truth.
Thank you. I'm just taking a look to make sure I haven't missed anyone. Believe that should be everyone. Thank you very much.
All right, back to your first witness.
Thank you, Mr. Chair. Ms. Donahue.
Thank you. Good morning, commissioners. My name is Jessica Donahue. I'm with Ardor Environmental, here today on behalf of Gunnison Energy. While this is the first OGDP Gunnison Energy has submitted to the ECMC, Gunnison Energy has been an operator in Colorado since 2014. Gunnison Energy's operations are focused in the Piceance Basin, and their assets primarily produce dry natural gas. Gunnison Energy currently has 27 active wells, the majority of which produce federal minerals. Gunnison Energy is committed to developing its leasehold with a focus on public health, safety, welfare, and the environment. Gunnison Energy is an Option 1 operator under the 700 rules and has an approved Form 3. Today, Gunnison Energy is bringing you the IPU lower OGDP. This location is, We're proposing a single location OGDP that will entirely utilize existing oil and gas disturbance. No new disturbance is required for this project. This project will add 6 horizontal wells. The proposed location is in the northeast-northwest of Section 24, Township 12 South, Range 94 West. The existing location is 6.008 acres. Once all the wells have been drilled and on production, the location will undergo interim reclamation and be brought down to approximately 0.06 acres of disturbance. The nearest public crossroads are County Road 265 and County Road 1. This is an image of the location taken a couple weeks ago, just to give you a latest and greatest view of it. The location is in Delta County. Gunnison County is the proximate local government. There are no school facilities or inhabited structures within 2,000 feet. Under the ACS 5-year 2019 data shown here in the map as the yellow and orange, the IPU lower pad was within a disproportionately impacted community. Under the revised definition from May of 2023, shown here with the red polygons, it is no longer in a DIC. And the location has an EnviroScreen score of 20.664. The Iron Point unit is a federal unit. The project will develop approximately 5,292 net mineral acres. The location is on private surface owned by Hotchkiss Ranches, which overlie federal fee minerals. The proposed horizontal wells will reach federal minerals regulated by the Bureau of Land Management. Gunnison Energy did receive its federal APD approval on September 28th, 2023. And from the IPU lower location, the proposed wellbores will extend north and south of the location to maximize mineral development while minimizing surface locations necessary. This project was designed to minimize overall impacts in the area. Gunnison identified an existing oil and gas location and that could be utilized to drill the 6 proposed wells without requiring additional surface disturbance. The IPU lower 1291 number 1324 location was originally constructed as a tank battery facility. It had modular large volume tanks installed on the location, which, as you can see, right, the giant circles that you can see here on the image, but they have been deconstructed and they are being removed from the location. The tank battery is being decommissioned under an approved Form 27 remediation project number 28888. While these 2 locations were permitted as separate facilities with ECMC, they are looked at as one location under BLM, and they will work symbiotically with each other. There are 2 wells on the Iron Point Unit Hotchkiss 1291-1324 location, or the upper pad. One of those wells will be plugged and abandoned as part of this project. All production equipment will be installed on the upper pad. Flow lines will connect the proposed wellheads to the upper pad. As you can see from the image here, the lower and upper pad disturbances do touch and they are connected. So we had consulted with staff prior to submitting the application and confirmed that due to the fact that flow lines, even though they go from one facility ID to the next, because they are going through existing disturbance and there's no gap in between that disturbance, they will be considered as on-location flow lines. Connecting at the IPU upper pad is the IPU, I apologize for that. The IPU upper pad is already connected to a gas gathering pipeline system and Gunnison's produced water system to minimize trucking. Gunnison Energy submitted the IPU lower OGDP on October 20th, 2022. Gunnison worked with staff to meet or exceed ECMC standards and to ensure that staff understood the complementary relationship between the 2 locations. Gunnison received its completeness determination April 4th, 2023. Public comment period ended on May 13th, 2023. On August 30th, 2023, staff issued the director's recommendation. And as I mentioned earlier, September 28th, 2023, Gunnison received its federal APD. So the initial phase for this location will be it's not construction because it's an existing disturbance, so it's more of a location preparation. There will be no expansion, no new disturbance. The dashed red lines that you see here in this image is the total oil and gas location disturbance area. The solid red line is the working pad surface. Location preparation activities that will occur prior to the drilling of the proposed wells will be decommissioning the MLVTs, leveling the working pad surface, and installing gravel. Gunnison is proposing to drill this location over multiple drilling occupancies. This will allow Gunnison to meet their BLM federal unit drilling obligation timelines. Drilling is estimated to be approximately 5.5 weeks for the first occupancy. Drilling will be a 24-hour operation to minimize the time the drilling rig is on location. Gunnison will use a closed-loop drilling system, and they will use freshwater mud to drill the surface hole and synthetic-based mud for the rest of the well, which will minimize their water demands as well as optimize their drilling operations. Completion activities will also be conducted in multiple occupations. Gunnison has committed to using Tier 4 engines for completions. They estimate that the first occupancy for completions will be approximately 3 weeks. Completions is also a 24-hour operation. And they estimate that there will be approximately 535,000 barrels per well of water used, and up to 70% of that number may be recycled water. This image here is a screenshot from a location that Gunnison drilled a couple years ago, just to give you a feel for how their specific operations may look. They do utilize minion tanks. And as you can see, what looks like a giant slip and slide is their secondary containment for those minion tanks. So they utilize muscle wall and make sure that they calculate so that should there be any kind of concern with the minion tanks, there's plenty of secondary containment to withhold it. If you're not familiar with muscle wall, there's actually several very interesting videos online where the Army and other military pieces have used it for different emergencies, and what you can watch them test it for catastrophic failures and how it can withhold and withstand a rush of force and water. Once all proposed wells have been drilled and completed, the IPU lower location will undergo interim reclamation. Due to the fact that the production facilities will be consolidated at the upper location pad, this location will be brought down to approximately 0.6 acres, highlighted here in the green, which will just be the working room that you need around the wellheads. Gunnison Energy anticipates that they will begin preparing the location before the end of this year. They anticipate they will contract a rig and commence the initial drilling operations to occur in second quarter of 2024. This will allow Gunnison Energy to meet its contractual obligations as well as federal unit obligations. Completions and flowback will occur in the third quarter of 2024, and the well should be producing by the fourth quarter of 2024. As mentioned in our introduction, Gunnison Energy is committed to developing its leasehold with a focus on public health, safety, welfare, and the environment. Throughout the planning process of this location, Gunnison Energy has heard the community's concerns and has taken that into consideration when planning this project. Gunnison responded to each and every public comment, addressing the concerns expressed. Many were duplicative in nature. Gunnison's response to the public comments was thorough, robust, and was meant to ensure that people knew their concerns were heard, reviewed, and addressed. There were 3 concerns raised most often. These were water quality, water usage, traffic impacts to the community, and potential geologic hazards. Gunnison Energy has incorporated operational practices and best management practices into their operations to address these potential concerns, which we will go into further detail on the upcoming slides. Gunnison Energy is aware of how precious a resource drinking water is, as well as the agricultural water that the surrounding communities utilize for their farming and ranching operations. Gunnison Energy operates the Hotchkiss Water Storage Facility, pictured here, to be able to store produced water and recycle it to support drilling and completion operations. Gunnison Energy also utilizes industrial designated water for its operations. Gunnison Energy does not withdraw any fresh water from Paonia Reservoir. The IPU lower location is 599 feet north of Cottonwood Creek, an ephemeral stream. Cottonwood Creek feeds into Hubbard Creek and is within 15 stream miles of a Rule 411A surface water supply area. In accordance with Rule 304C1, Gunnison Energy prepared an emergency spill response plan that was reviewed and concurred with by Delta County. In addition to meeting these requirements, Gunnison Energy thought it would also be prudent to have a potential spill analysis prepared. Mr. Higley with WWC Engineering prepared this analysis, reviewing the hydrologic factors in the project area, the location's proximity to Cottonwood Creek, and the proposed volumes of fluids to be stored on both the IPU lower and adjacent Iron Point location. The analysis concluded that due to the ephemeral nature of Cottonwood Creek and the distance to Hubbard Creek, the probability of a potential spill at the Iron Point or IPU lower location affecting anything downstream is extremely low. Gunnison Energy has a produced water pipeline system in place that it will utilize to deliver water to the IPU project area. The nearest community to the project area is the town of Somerset. Somerset is a historic coal mining town and has existing railroad access. To further reduce truck traffic in the area, Gunnison Energy has arranged to bring in the sand for completion operations via rail to Somerset. If Gunnison Energy hadn't made these arrangements with the coal mines to utilize their existing railing, all sand would have to be trucked from the town of Fruita, and it would travel through the towns of Grand Junction, Delta, Hotchkiss, and Paonia. Additionally, by utilizing the water pipeline delivery and railroad for sand delivery, it eliminates the majority of truck traffic that would be along Highway 133 and the yellow-billed cuckoo proposed critical habitat that was identified west of Somerset during the environmental analysis with BLM. During the initial preparation of the geologic hazards map, Gunnison Energy did identify polygons that would be considered potential geologic hazards within a 1-mile radius of the location. Gunnison Energy engaged with Geosyntech to further evaluate the potential hazards. Gunnison incorporated several best management practices based upon the data reviewed during this geologic hazard analysis. Some of these BMPs are listed here, such as monitoring site conditions, ensuring adequate surface drainage is incorporated into the location, and not injecting any wastewater within 1 mile of the oil and gas location. Gunnison Energy additionally requisitioned a site-specific INSAR study, which evaluated potential landslide and slope concerns. The INSAR study identified the nearest landslide movement 8 miles to the east at the known Muddy Creek Slide, which is east of Paonia Reservoir, and south near the coal mines outside of the 1 mile radius. Gunnison Energy also conducted geotechnical borings at the existing location, which reduced their initial assessment to a low risk for collapsible and expansive soils. Some of the best management practices that Gunnison Energy is implementing to protect air and air emissions will be items such as the traffic reduction practices that we mentioned earlier will not only reduce general nuisance traffic factors, but they will also help reduce the vehicular emissions in the area. Gunnison Energy will utilize a Tier 4 completions rig for their operations. The existing equipment on the adjacent Iron Point location will be upgraded to no-bleed pneumatics. Production equipment will be consolidated on the Iron Point location and connected to natural gas and produced water takeaway pipelines. These BMPs and operational practices will help reduce Gunnison's potential NOx emissions. For lighting, lighting is going to be temporary only on this location. There will be no permanent lighting at all. Lighting will be on location for drilling and completion operations since they are 24 hours. The lighting will be downcast and task areas only oriented so that it will minimize the impacts across the landscape. And with that, I'm going to turn it back over to Chris.
Thank you, Jessica. So we're just going to go over a quick summary of the permit. Again, we appreciate your time. So the IPU lower location does utilize existing oil and gas locations, and there is no new disturbance. We think that's very important as it was done in order to reduce that footprint, utilize already existing infrastructure, and be mindful of the surrounding conditions and surrounding land. We are maximizing the distance to cultural receptors in order to comply with and exceed ECMC standards. We optimize proximity to natural gas and produced water pipeline that Gunnison installed, and as well as its own takeaway infrastructure. And overall, we believe this permit minimizes the impacts on public health, safety, welfare, wildlife, and the environment. We believe that this presentation has illustrated as such. Next slide, Jessica. Please. So as you'll see, this is just a small sampling of the standards that Gunnison has exceeded. Water protections in 602J and 411. There was a voluntary spill risk analysis report. A spill kit will be on the Iron Point Hotchkiss 13-24 location. With respect to geologic hazards, which we know has been raised by the public and the petitioners, that's 304B71, and there's a voluntary INSAR study with geotechnical soil borings that was conducted. With respect to air emissions, we have committed to Tier 4 completion engines. With respect to freshwater reduction, as you heard, we are using up to 70%, up to 73% recycled water. With respect to traffic, there's rail sand to the project area, pipe water delivery to the location, pipe production water to water storage facility. With this in sum, as we note, this is a project that will develop 5,292 net mineral acres and is located on private surface by Hotchkiss Ranches, who owns the overlying fee minerals, and the proposed horizontal wells will reach those federal minerals regulated by the Bureau of Land Management. We would like to emphasize we have received federal APD approval. With this location, again, we want to emphasize was designed to minimize overall impacts in the area. We identified this existing location because you could be utilized to drill the 6 proposed wells without that additional disturbance. And we would also like to again emphasize that we are committed to developing this leasehold with a focus on public health, safety, and welfare and the environment. Throughout this process, we have heard the community's concerns and taken those into consideration when planning. We would note on a slight deviation that a significant portion of the petitioner's concern and the apologies, I was off video. A significant portion of the petitioner's concerns and requests are notification or information that they can either get themselves from public resources or provide their own monitoring. For example, they've talked about the geologic resources, the USGS sites available, that's the spill reporting that requesting for, that's all publicly available. So we just want to make sure we get in the record that we have responded to those questions and we responded to those public submissions with detailed examples and illustrations of the efforts Gunnison has put forward to address those concerns and make sure this permit is one of the leading permits that's ever been submitted in this state. Again, we'll note 3 concerns that have been raised most often were water quality, water usage, and traffic impacts to the community, and potential geologic hazards. Gunnison has incorporated operational practices and best management practices into their operation to address these potential concerns, and then we'll go and we have used this presentation to illustrate those in a thorough nature. We'll now reserve the rest of our time for rebuttal, unless any commissioners have any questions.
Thank you, Mr. McGowan, for the presentation of the case in chief. I think before we get into whether there's questions from commissioners, I think it's standard practice that I should allow for Mr. Foote to cross-examine any of the witnesses that you brought forward. It wasn't in the case management order, but that is a standard procedure. So, Mr. Foote, I would allow you an opportunity if you have any questions.
No questions on cross. Thank you.
Okay. All right. Then
Mr.
with
Chair,
the case, I'm sorry, Mr. McGowan.
I apologize. I don't mean to interrupt, and you're absolutely right. I do have one more slide. I actually should request and respectfully request that you adopt the permit. I forgot to add that, and that's my apologies. But we would respectfully request that this commission approve the IPU lower OGDP. And again, we do want to make a very important thank you to the staff and to the ECMC. They've been a very good partner in this process, and they've worked diligently to work with us during the development of this location. So we do want to put out a thank you to the staff for their efforts in this endeavor as well. Apologies for the interruption.
No problem. I assumed that would have been your request at any rate. If you want to remove the slide deck, it allows me to see everybody a little bit better. And with that, commissioners, we've got the witnesses available or witness available for any questions you may have. Commissioner McGowan.
Thank you, Mr. Chair, and thanks for the presentation today. It was helpful. I think one of the questions from the petitioners was about the geologic hazard plan or study and the lack of consideration of the landslide possibility to the west, I think, from understanding. I think you kind of touched upon this in your presentation, and in your written materials, I think you explained maybe during the study why the entity that did the study thought it wasn't necessary, and I'm wondering if you could elaborate on that a little bit. I hope I'm explaining myself.
Yes, Commissioner, thank you for the question. I'm going to defer to have either Mr. Laverne or Ms. Latasi respond.
Thank you,
Mr. Laverne.
Thank you, commissioners, for your time here. I'll go ahead and take the front end of that question, and I'll just give you a little bit of background on myself. I'm a geological engineer, graduated from the Colorado School of Mines, and I have experience working in this specific project area with Bowie Resources since 2008, or beginning in 2008. And in 2010, I worked with a consulting company that specialized in geologic hazard evaluations on international projects. I've been in-house with Gunnison Energy as the acting geoscience director and subsurface manager since 2018. And I'm actively over in that similar role as a consultant. And I would like to give you a little bit of a background on our approach to understanding landslides in the area. And the starting point for that is with the Colorado Geologic Survey landslide polygons that Ms. Donahue mentioned earlier in her presentation. And those are very extensive throughout the Rocky Mountains. And the one thing that we are very concerned with is the concerns of the community and CHC and Terra Creek Ditch and Terra Creek Reservoir. And we have a history of working with them on projects and trying to get their input and understand their concerns. In 2018 and 2019, we acquired a 3D seismic project in the area, encompassing 17 square miles. During that time, we reached out to Terra Creek Ditch and the representatives and their president to try to understand the extents of their ditch and their reservoir and the creek. At that time, they were unable to accommodate our request to meet in the field to understand the extents and the possibilities of concerns in that area. Regardless, when we moved forward with this IPU project and permit, we understood the concerns of landslide polygons, and it did trigger the geohazard risk and the geohazard plan that Martina will go into more detail on. And she is the licensed professional geologist that did the evaluation of all geologic hazards that were possible in the area. So the rule that we evaluated required a 1 mile radius. The geologic hazards specific to the CGS landslide polygon extends outside of that. So we extended our evaluation outside of that 1 mile radius specific to landslides. Knowing that it was a large area to understand, we commissioned a INSAR study, which is known as a, excuse me for the delay, it's a long, lengthy word, and it's called interferometric synthetic aperture radar. And this is an advanced technique to understand spatially the risk of landslide movement. And I came across this tool from a study that had been done by the Colorado School of Mines in a paper by Ben Lowry and his colleague, Scott Baker, who's a PhD from Georgia. So we decided that could be a good resource to understand the risk of landslides in a broader area. So it uses satellite data and it takes measurements of horizontal and vertical movement differences and with velocities of the surface. And using that data, they can understand persistent movement. And the persistent movement that we see in the area, which we evaluated, included the west and the east, several miles outside of the 1 mile radius. And we saw that the persistent movement matched their original paper, which was the Muddy Creek slide 8 miles to the east of our project area. And that landslide is a well-known landslide, and it's to the east of Paonia Reservoir, where Highway 133 used to exist. They moved the highway to the other side of the reservoir because of that landslide. So with our analysis, we wanted to make sure that we could understand the landslide risk and the community concern, and we feel like we've done that and we've exceeded that standard. And at this moment, we haven't identified anything within the 1 mile radius or anything in the area that shows persistent movement. We do see persistent subsidence movement to the south, and that matches the exact extents of the existing coal mines. And the existing coal mines are at least, I think, a mile away from any of their infrastructure. I was able to map their ditch and their reservoir and the creek, 3 different components of the Terra Creek nomenclature. And the closest point is over 3 miles from our working pad surface for reference. The closest point to any proposed subsurface point is approximately 2.8 miles away. So we feel like any impact would be negligible or minimal based on the existing distance. So we're happy to address concerns and evaluate, but we feel like we've gone above and beyond. And I would like to give a chance for Martina to respond and talk about her independent analysis. These are she's with Geosyntec, and they've done geohazard evaluation for numerous operators. They're independent experts. We wanted their independent opinion. We provided various proprietary data sets for them to help their analysis, including 3D seismic. During that 3D seismic, we had sources on the surface over that 17 square mile data. and that had shallow source points where we got 20-foot borings of the soil. So we took that into consideration. And most recently, as Chris mentioned, we did a geotechnical study on the working pad surface to understand the soil risk. And we did additional lab testing using moisture contents and dry unit weights, and have come to conclusions that the risk of soils is low, soil geohazard risks. So if you guys are okay, and I understand there's a time constraint here, and happy to go into more detail, but I'd love for Martina to have the chance to talk about her independent analysis and integration of all that data in her conclusions.
I'll defer to my other commissioners as to how much they want to hear about it. But that was helpful for me. I'm wondering if you could fold in, and maybe this isn't relevant, but my other thought was you've drilled at a location right next to the proposed location where you used to have the storage tanks, right? Did you, in that other location, which is adjacent, I think, did you all experience any seismic activity? And did the study that you commissioned consider activity that you've already done right next to where you're proposing to drill? And is there any interplay or lessons learned from what you've done before?
Yeah, I'll take a crack at that. It's a great question, and I would like to reference the geohazard plan and the geohazard study that Martina put together. And the last known seismic event within the 1 mile radius was, I believe, in 1944. So there's a lot more activity and events of seismic events that are near the coal mines, because they mine 10 feet intervals of the mountain, which are removed, and we won't be removing any rock material besides the diameter of the bore. And so during that time, we don't have any record of additional seismic events or seismicity. There was a completion which induces water and for fracture, and our micro seismic that we have on other project areas shows very minimal fracture widths and fracture heights. And that is probably the most relevant data that we do have from the techniques that we apply. And sorry if hopefully that got you close to the answer, if I understood it correctly.
I think so. I was just, it seems to me that if you're kind of you're in the same place, same kind of geologic areas, a space where you already drilled, that maybe we have some idea of what to expect if you're in that same area. I was wondering if that was true or if that's just a layperson's assumption.
Yep, I think that's a great assumption, and I think it's safe to say that we didn't see major risk from the first project area, which began in 2010 or 11, and I think segments of it ran into 2013. So I don't think we show evidence of seismic concerns from that project.
Second question, third question, I guess. Do you all submit information about spills to Delta County currently? Do you have like some sort of agreement with the county, and does it get posted?
If you don't mind, I'm going to defer to Jessica on that one.
Jessica's this way.
Yes, I can take that question. Thank you, Commissioner. When a event occurs, Gunnison Energy does notify Delta County. And also Gunnison Energy does have an agreement that even since their operations straddle the Delta and Gunnison County line, even when an occurrence may occur in Gunnison County because of the nature of the watersheds and the flow of the water, they do also, as a courtesy, have an agreement to notify both Gunnison and Delta County communities or governments, sorry, that something had occurred, and they'll give them the details and such of what happened.
And maybe you can't answer this question. Maybe this is for the county and they're probably already gone, but do they, I was curious to know if they posted it, so that we have other communities that we work with that post activities that are going on with operators. Heads up, they're going to be drilling this week. Heads up, there was a spill. Heads up. And so the community has a place to go to get that information, so that the operator, doesn't have to be responsible for communicating with lots of folks and then maybe something falls through the cracks, but there's always that consistency with the community within which they are operating. And so I get that you might not be able to answer that question, but I'm wondering if at some point in time we might be able to ask Delta County that question.
We can confirm that with Delta County. I'm not currently aware of if they post that knowledge publicly or if it's just disseminated amongst the local government designee and the county commissioners.
Other questions?
Madam Commissioner. Mr. Commissioner, it looks like Mr. Johnson would like to add a little something on that. I believe he has some knowledge that he could provide us.
Go ahead, Mr. Johnston.
Well, thank you, commissioners, for your time and thank you for the question. We do have pre-operations meetings with both counties to make sure that they are aware of all of our activities. When I know that they have repeated in the past that they want to always know what is going on, so that when they do receive calls from their county constituents, they can fully explain the situation, whatever that may be. Are there active drilling activities, completion activities, any incidents of any kind that may happen? So we do stay in close communication with them on that, as well as with the emergency services that are in that area, and we always preemptively have what we call a pre-operations meeting with them to inform them of all of our activities, estimated timelines, and anything that may change significantly in that manner.
Thank you. That's helpful. I would be interested in knowing if the county then posts that so citizens in the area also have that information. And if not, if you all are willing to have a discussion about the county being the repository for that information, it being posted so folks have access to it. That would obviously include the county being willing to do this too, but I'm trying to suss out some of the issues that we heard from some of our stakeholders. So,
Commissioner Cross.
Thank you, Mr. Chair. And I'll be honest, I think initially some of my questions I anticipated would probably come up during some of the rebuttal, but since Mr. Laverne did talk about some of the geotechnical aspects, I wanted to try and ask a couple clarifying questions. One is, you talked about the INSAR study that was done, and you mentioned persistent landslide movement being to the east, about 8 miles away. And then you also mentioned, I think it was subsidence related movement in the mines to the south. I think the first part of my question is, can you, for everyone's benefit, kind of elaborate on what the difference between the persistent landslide movement is versus the subsidence movement?
Yes, sir. Yes, sir. Great question. And we can go into more detail if necessary, but for the landslides movement, we're talking horizontal movement. In subsidence movement, we're talking vertical movement.
Okay. And then also clarifying on what you mentioned, you said, so for this, for the vertical movement, you mentioned the nearest was the old mines that were to the south. I think you said, and I think the report also said 2.5 to 5 miles away. But did you also clarify the distance of those mines from the ditch? Did I hear that right?
And I would have to do more precise measurements, but I do believe that with the records that I have, that they are at least 3/4 of a mile away from the mines, or at least the subsidence that I was able to see on the INSAR study.
Okay, so the mines are 3/4 of a mile from the ditch, but
that's three-ish miles. The nearest point is the reservoir, and from the reservoir, the ditch generally trends northwest, which gets even further away from the mine. And the connecting to the river, the nearest river, is the creek, naturally flowing creek, moves to the south.
Okay. Perfect. I'll save other questions for potential rebuttal. I just wanted to make sure while that was out there that I clarified my understanding of that. Thank you.
Other questions for the panel? Commissioner Messner.
Thank you, Mr. Chair. Just one question, because I'm want to make sure that I'm not missing some information. But In one of the responses to public comment, Gunnison Energy indicated, and this is about air emissions, but that air emissions were modeled using industry standard methodologies and have shown minimal impacts. I'm trying to find in the application where that modeling occurred or the results of that modeling, and I haven't been able to locate it. So maybe someone can direct me to that.
I'm going to direct that question to Ms. Donahue and Ms. Cox.
Let's say thank you for the question, Commissioner. I will defer to Ms. Cox as the air expert, but my understanding is the modeling that occurred that was referenced is from the federal environmental assessment that had occurred for this location. And I think she can give you a little more color to that.
Okay.
I can give you more color. She's correct in where those emissions exist. And maybe we can provide you some more information on them. But the modeling is done by source, and we do it both for the pre-production activities and the production activities. And they all have typical sources, and we use, approved emission calculation standards to do that. So I'm not sure if you want me to run down how each source is calculated or just generally talk about the total emissions that are emitted during each phase. I'm not sure what would help most.
I don't need you to go through it. I was just trying to locate where that information was in the application. And it sounds like it was part of a different application to the federal government and as part of their permit requirements. Sometimes we see that federal or local government approval in our information, and I'm not seeing it there. So I just was curious whether that was submitted or whether I'm just missing something, because I often try to cross-reference that information as I'm reviewing an application.
As Ms. Cox said, the modeling itself and the backup documentation were part of the federal NEPA process, but the numbers that came out of that work was what was submitted via the Form 2B for the state.
Okay, thank you. That's the only question I had.
Yes, thank you, Commissioner. Sorry, I didn't start with that.
Commissioner Ackerman.
Thank you, Mr. Chair. Just one question from me at this point as well. And I think I heard you say that there is some nearby oil and gas activity and that you don't expect geohazard issues with this activity based on the lack thereof from previous activities. I took a look at our database and found a number of historic oil and gas activities in the area. Could you elaborate just a little bit on that? The previous activity that you referenced, is that also a horizontal drilling activity? And what's the nature of that activity and what's its proximity to this one?
Commissioner Ackerman, I can start hopefully with an answer for that, and then I may defer over to Mr. Laverne or Mr. Nabavian. So as you can see, this is a established oil and gas field. On the very adjacent pad to what we are proposing, there are two wells. One was a vertical, one is a horizontal. To the north, there are some other traditional shallower vertical wells. And so Gunnison Energy has been exploring this area for minerals for approximately since 2014. So 9 years. If my math is right. No, longer than that. Almost 20. I can math today. Yay! So, and then I will defer over to Mr. Nabavian, and he can give you some insight into the other operations of the area.
Yeah, thank you, commissioners. Not sure if you can see me or not. I turned my video on. That first pad on the top side, that was a horizontal. It was in the Niobrara formation as well. And the second well that we are planning on plugging and abandoning is shallower. That was a vertical well that was in the Cosette formation, approximately 2,000 to 3,000 feet shallower than that horizontal vertical depth. For these two wells, we're going to also be in the Niobrara. The Niobrara is 800 feet thick. So that original well actually landed about 300 feet above the base of that Niobrara formation and actually went up dip in essence. And it eventually poked into the bottom of the Mancos B. The Mancos B is directly above the Niobrara. And that Mancos B and A form is about 2,000 feet thick before you hit the Cozette Corcoran formation. These two wells will be landing about 150 feet deeper at the first point of that Niobrara, and then we'll be going down dip approximately 3 or 4 degrees. So as we're drilling, we'll be departing vertically from that original well, and by the end of our well, we'll be about 700 feet vertically delta from that original well, if that helps.
It does. Thank you, Mr. Nabavian. And that addresses the somewhat adjacent exploration. Is there other nearby exploration by Gunnison Energy?
That is the nearest Mancos or Niobrara well from this pad is probably around 5 to 6 miles away.
Thank you. I appreciate that. I guess I do have one further question, Mr. Chair. And if this was addressed and I missed it, I apologize, but I didn't see much of an explanation on why the 2 separate occupations. Can you elaborate on that a bit?
Mr. Johnston.
There we go. Sorry about that. Yeah, so part of this has to do with our drilling window. We do have a drilling window from April 1st through December 1st, I believe, are the precise dates for our federal operations under our federal unit agreement. So we do have a shorter drilling window, and we also have unit obligations. So we have to drill a certain number of wells in a periodic time frame in accordance with our federal unit obligations. So the multiple occupations is due to both of those factors, ensuring that we meet our federal obligations and also ensuring that we do not overlay our drilling window. We also are on fee property on this fee property. Fee minerals is where this well starts, and we have an agreement with the service owner to minimize any disturbance with this hunting activities, which actually starts well before December 1st, as you know. So we do our best to accommodate that and ensure that we can get our operations done, get out of there prior to the disturbance of hunting season. So that's another reason for us shortening our operations and doing, in this case, 2 wells at a time. This is actually going to be our first multiple well operation from a time frame standpoint. So we are going to utilize this as our gauge on will we be able to drill more wells in the same amount of time.
Thank you, Mr. Johnston. And Mr. Chair, I shouldn't enumerate the number of questions I have because yet again, I have another. And I missed one of my notes here, which was I heard a couple of times about the amount of recycled water to be used for completions. I heard 70% once and 73%. I'm assuming the 70 was just kind of a rounding. But I heard an up to. Can you talk a little bit more about why the up to, and is the operator able to commit to 70% recycled water?
Thank you, Commissioner, for the question. The up to language is because it will be dependent upon the volumes available from the Hotchkiss Water Storage Facility, the volumes that are received during flowback and during from other producing wells. So as Gunnison Energy goes through each phase of its operations, it hopes to maximize all of the recycled water it possibly can. But from well to well, it will be very dependent upon what's available in the ponds themselves.
Thank you. And so what I'm getting at there is, what might the floor be? If we say up to 73%, what might the floor be for recycled water use?
Let me elaborate a little bit. So those ponds tend to evaporate quite a bit during the winter, approaching the summer. So even if we're full, we might lose 30-40%. We're estimating right now each well is 535,000 barrels per well. So call it a million plus total barrels. So that's number one, understanding the evaporation process. Number two, we are planning during the completion operation to consistently be pumping from through our pipeline. Now that pipeline happens to have ratings, pressure ratings, burst ratings. It's a 6-inch pipeline, and it's traveling approximately 12 to 13 miles around our field and very large elevations too. So if you have a humongous pump in the front, you might actually have a spill because you've over exceeded your ratings. But what we are committing to is during our operation, we're going to be pumping real time, whether the ponds, displace and there's not much more water, or the speed of the rate isn't sufficient to get up to a certain percentage. That's why it's very hard to exactly say the number, but our plan is to consistently pump throughout the completion operation.
Thank you. That's really helpful. And I think just to kind of put a finer point on it, is the goal then to use 70%? Is that what you anticipate and you're just hedging because of the issues that you brought up? Or would that be, kind of best case scenario?
If our well is short, so, our last well, we were planning on 7,500 feet, for instance. We ended up with 6,000 feet. These wells we're planning on, even the permits are longer, we're probably planning on 7,500 feet on these, but we actually might end up with a much shorter well, hence much less water, right? So that's a real time issue that might happen to us. So as we're saying, 73%, there's a possibility we can get that high because our water won't be as needed. But if we achieve our goals and we have the longer wells and and based on our modeling on the engineering, my assumption is we'll be less than 73. I'm just not sure how much. So that's why we left it pretty open-ended. All I can promise is that from best practices and making sure we're prudent operators, we're going to be pumping in a safe manner through our pipeline consistently throughout the entire operation.
Thank you, Mr. Nabavian. And the reason I bring this up is because we did receive some concern about water use associated with this. And I just wanted to clarify that all water use is intended to be this type of industrial water, but not domestic or agricultural water. Is that correct?
Correct.
That is correct.
All right. Thank you so much, Mr. Chair. That's it for me for now.
Okay. One final question, at least one question for me, and I'm not sure if now's a good time to raise it or not, but I did note from the pre-hearing statement from CHC, pages 9 and 10, they denote what they believe are some application inconsistencies. At some point, Mr. McGowan, I would like you to address that with your witnesses. And
yes, Mr. Chair. Sorry, go ahead.
I was just going to say, let us know whether you believe the inconsistencies are accurate or not, and if there are inconsistencies, determine which piece is the fact versus not fact, etc.
Thank you for the question, Mr. Chair. So we can do it. We can actually do it right now, or you can wait till I rebuttal, your choice. But we did have those. We have those addressed. We actually have rebuttal slides ready. I'm happy to answer those questions. If Ms. Donahue could pull up our rebuttal slide and go to that particular section, but we can wait. But yes, Mr. Chair, we do have those addressed.
Okay.
And they're all straightforward answers. Yes, sir.
All right. Then let's do this. Actually, I'm first looking at my fellow commissioners. Are we done with questions on direct? Yeah, it looks to be the case. Okay. Procedurally, we need to take up the commissioner feedback on cumulative impacts information docket. And so we're going to need to take a break from this hearing so that we can hear from Tricia Oath from CDPHE. I think we also need a break. it's 11:30. Let's return at 11:45. And at that time, let's hear from CDPHE and finish up that aspect of our docket. And then following that, and depending upon how long that takes, we may start this back up with case in chief from Mr. Foote, or we may take a short lunch break so that we're ready for the afternoon. So with that, let's break for 15 minutes. Let's return at 11:45. Hearings manager Thomas, if you could let Ms. Oath know that's the time frame we're looking for, and then we'll see everybody back for the cumulative impacts portion of our hearing at 11:45. Thank you. All right, welcome back. This is the Colorado Energy and Carbon Management Commission, Wednesday, November 15th at 11:45. This is our normal business agenda. At this point, we're going to take up a docket, or not a docket, but the commissioner, it's illustrated as commissioner feedback on cumulative impacts informational docket. And I think in particular, we wanted to hear from Tricia Oath from CDPHE, our sister agency. Good to see you with us. I'm glad we're able to take a break and get to you. The floor is yours.
Oh, thanks, Commissioner Robbins, and really good to see everyone here today. Sorry I was not able to join last week, but have gotten up to speed from my team and really appreciate all of the conversation that you all have had so far, and particularly all of the input that we've gotten from a number of the community members on the topic. So happy to be here today. I'm happy to provide some initial remarks. Was hoping really to have discussion. Want to hear more about what you all are thinking, any questions that you have, or if there's anything in particular that I can share about what we do at CDPHE. We did have a chance to send over some written comments, which I think really sort of summarizes some additional presentation that Sergio Guerra and others on our staff have been able to share with you previously, just about kind of what we do in terms of modeling and tracking emissions on our end. I think we're all very committed to figuring out how do we best move forward on cumulative impacts, but also wanting to be, just wanting you all to be aware of the things that do or do not happen at CDPHE's end, so that we don't inadvertently create a solution that is duplicative or something that's just not implementable or something like that. So we're approaching it from that standpoint, just wanting to kind of share with you all the things that happen on our end, provide any clarifications, and kind of just engage in the discussion with you.
Great. Does any commissioner desire to lead off? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Commissioner Oath, for being here today. So I think hopefully your staff was able to talk to you about what I will call some themes that came up during our stakeholder process, and places where I think folks are looking for better collaboration and consistency between the two agencies. And for me, I'm wondering if we could start by talking about NOx and the rulemaking that CDPHE is going through, and how we might be able to tie industry goals for meeting NOx reduction targets and goals, how we tie potentially our OGDP process and application and approval to whether it's verification or meeting goals over on the CDPHE side, and if you and your staff had time to think about that kind of big picture proposal.
Yeah, great questions, Commissioner McGowan. And so we do have the Air Commission has a rulemaking hearing scheduled in December. There are a number of components to it, including kind of three elements specifically targeted at the oil and gas sector, and particularly designed to achieve the 30% NOx reduction goal directed by the governor to really both of our agencies. So those three pieces, I'll do my best to describe them well. So one piece has to do with engines. And so these will really be kind of straightforward emissions standards on oil and gas and diesel engines. And then, you know, we do have existing ones, but the proposed standards will be more stringent than what has been done in the past, and then also apply kind of more broadly to more engines than the existing standards do. And then a second piece is best management practices for drilling and fracking. So these would be tech-based standards, and of which, so it's like based on the equipment, what kind of equipment can be used. And then the third part is probably the part that I think has come up a lot, maybe warrants some discussion about how could we collaborate, or is there, a way to incorporate some thinking about it into the ECMC process, and that's the NOx intensity standard. So, we're proposing what would be, company-wide NOx standards for those operating in the non-attainment area during the ozone season. I've been struggling or been reflecting a lot about, what I've been hearing about the themes from what you all have been talking about, and how do we figure out how to ensure that facilities are going to, meet the target. And I've been thinking about that because in many respects, the targets that we have, like for greenhouse gases, for example, and even this NOx 30% reduction target, these are sector-wide targets, right? They're not, company specific or facility specific. I mean, when we get to the intensity standard, then we're talking company wide, but it's still not on a facility by facility basis. So I think that warrants some conversation about trying to figure out how to, if there's a way for there to be consideration of that in the ECMC process.
Thank you. So for me, I'm looking at a way to figure out how we could use the OGDP application process to help ensure that we're not continuing to approve things if an operator and or I guess industry is not on target to meet the goals for our ozone goals, NOx goals, and or greenhouse gases. So those are two pieces that I've been trying to figure out how we could use kind of CDPHE as a feedback loop, as a verification, because as you know, the estimates happen here. And then what actually happens is over on your end. That being said, I'm wondering if there's a way that we could also figure out how to align our permitting processes. So some of the feedback we've gotten from folks is maybe waiting until some of the modeling that has to be done on a per operator basis as part of your permit application process could feed into our approval process, like a red light, green light kind of thing. I'm wondering if your staff has thought about that a little bit.
Well, I can say we've talked a little bit about, would there be a way, and maybe this is similar to what you're talking about, but like for your permits to be kind of done on a, contingent basis, right? So you go through your process to evaluate, based on the information that's known at that time. And then, as you said, then, as the site continues to develop and we have additional information about equipment use, the details that we're then able to feed into our modeling. So we do our modeling, and then we, maybe there are some design changes that are needed in order to ensure compliance with the NACs and or the targets. Could there be a kind of the feedback loop or the contingency then of, well, then it's, they have to go through that, you make a contingent some way on them passing modeling and ensuring that there's going to be compliance and, meeting of the targets, and then it circles back to you in some way. We have talked about that as being one possibility.
Thank you. Another piece that I'm hoping that maybe your staff can think about along with our staff. how we collect data in the Form 2B or our Form 2As, how accurate it is, how we link it to the estimates versus actuals over at CDPHE. Are there pieces missing? Are there pieces that could use more alignment, so that that data can be better used? And I don't have any answers for that, but I'm hoping maybe our staff has been thinking about, I know for me, the 2B, for example, this is not related to CDPHE, but when our operators are talking about, I'm going to plug 20 wells, I'm going to drill 16, I'm going to plug 20. As a commissioner, I'd like to know if there's emissions benefits related to that, as we're keeping track of, I don't like the total amount of what's happening. And does that help with our greenhouse gas goal? Does it help with any of our NOx goals, or doesn't it? I think another idea that has been discussed is net zero impact under certain circumstances, perhaps related to disproportionately impacted communities. I know that the Air Quality Control Commission discussed these kinds of the net zero concept a little bit, disproportionately impacted communities, the definition of cumulative impact. I'm wondering if you could talk a little bit about how the conversation went over there, and if there's a way for us to align so that there's consistency for definitions, there's consistency for how things are applied, how decisions are made. So whether you're someone who's watching what's happening in both sandboxes, it feels consistent. Whether you're an operator trying to play within the bounds of both sets of rules, there's some consistency. And so I don't know if that came up with your staff as part of discussion.
Yeah, yep, happy to talk about both of those things. So the first part you were talking about, I agree. I think our staff could accomplish a lot getting together to talk about how do we better align the data in our OnGare with what goes into the Form 2B, and what kinds of changes could we make, so that in the long term we can be able to use our inventory report as a check against what goes into the 2Bs, right? And so maybe there's some ways, and I'm not going to say that I know the specifics of what should change, but I agree with you. I think that would be really helpful and beneficial to have our staff get together and kind of talk about how to make those work together a bit better to achieve these goals. On the second part of that, in terms of aligning our thinking and what has been done on our end, or with this in particular with the Air Quality Control Commission, with respect to disproportionately impacted communities and defining cumulatively impacted communities, yes, would be happy to share about that. So in May, the Air Quality Control Commission adopted some rules that did define a cumulatively impacted community. So the definition in short is looking at census tracts with an EnviroScreen above 80. And so for cumulatively impacted communities, then there are some enhanced monitoring and modeling requirements that come into play for sources in cumulatively impacted communities. So I would agree. I think, I think that would make a lot of sense for, our agencies to have similar or not similar, but identical definitions.
Those are the biggies for me right now. So I'll let some other commissioners take an opportunity to take advantage of your presence.
Others with an opportunity to chat? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Commissioner Oath, for being here. And I would agree with Commissioner McGowan. I mean, those were kind of the big themes that I think were talked about. I think for me, what I'm hearing, and experiencing, is really a need to better marry ECMC permitting processes with CDPHE permitting processes, and for them to be able to talk to one another, so that we're clear what each other are doing through the process. And I think during the last hearing, I had proposed just a conceptual life of an OGDP review that may include kind of a better marrying of the CDPHE review processes and the ECMC review processes, including some verification concepts for certainly, construction and pre-production activities, some preliminary modeling if appropriate, and application of VOC standards, of NOx standards, of whatever standards that CDPHE or thresholds that CDPHE has developed through the different rulemakings, to be able to then talk to our process after an application is deemed complete and we're both in technical review, and that hopefully these processes would be the start of the CDPHE process as well as the start of the ECMC process in a technical review type of timeline. And so it sounds like what you're saying is that some of this may be possible, and there's certainly devil is in the details, and what level of review these things go through, or what stage it would need to be at for CDPHE to be able to have some of this included in a recommendation or a consultation that's provided to ECMC to talk to our permits, and then even to develop some sort of staging so that we're not approving stuff and operators are beginning to drill before we know the answers to some of these questions. And I think that's one of the challenges that we face here, is that in some scenarios it may be that under current processes that operators may be able to begin drilling or begin operations before even knowing whether or not some of these things are being met or are being evaluated. And so is that what I'm hearing you say, is that there's a potential path forward here as far as looking at some of this stuff?
Yeah, thanks, Commissioner Messner. I think we're certainly committed to finding a path forward, right? I think this is really important. I think we see the really big challenges with kind of doing modeling earlier in the process than where it's done right now. I think from largely a technical standpoint, right? That at the time of an OGDP, we just don't have the kind of information that's needed to do the modeling. So I think what could be, so I don't think that we would be saying like, let's do an additional step of modeling, but more like maybe the check is again, like your permit could be like that if you want to make sure that that modeling is completed before they really have the go ahead to start drilling. I think it would be you would provide a contingent approval, and they would continue through the process, and then once they've passed through modeling, then either it could come back to you, or maybe that it just would automatically trigger approval then once they've passed modeling. I don't know what the details of that, but I think that is something that's workable. But I think both it's a resource thing. Like I don't think that we are able to, or we don't have the resources to be able to do modeling on these on all of these sources twice, right? To be doing it earlier in the process, and then again when we do, and also I think there's the technical challenges, but I think there is a path forward to connecting them kind of through this other feedback loop that we've been talking about.
Okay. So, and I understand the challenges of modeling. I guess I'm still gray about kind of the level of detail in the OGDP, because it appears to me, at least in the conversations that I've had, that the level of detail once it gets to technical review is pretty, is pretty detailed, I guess. I mean, we know we've got construction documents, we've got facility types, we've got engine types, at least that are being proposed, right? And so I mean, there would be a burden on the applicant to propose things that were the best that they could do in these particular situations. But I guess I'm not totally understanding the level of detail necessary that is not provided in the OGDP, and we don't have to like figure that out right now, but that's still a little unclear to me, because certainly Sergio has talked about stack heights and distances from certain
Yeah.
things and, understanding some of these things, but it's not clear to me that that's not available in the OGDP once it hits technical review. And so maybe we can get into the weeds on that at some point in the future. And then understanding that modeling, it's a big step, particularly in situations where modeling occurs. It also is clear to me that modeling is not going to be required in a significant number of OGDPs that may be reviewed, because some of them will be aggregated, some of them won't be aggregated. We may not be looking at things that are going to pass the threshold to require major source threshold in order to require modeling. And so one of the questions that I've been asking is, what are the opportunities available, in reviewing these in partnership with CDPHE that will better capture construction, pre-production, and then the full suite of activities that may be occurring on a pad or pads associated with an OGDP that includes different stationary sources and production equipment that may or may not be aggregated right now for determination of whether or not modeling is required.
Yeah. In terms of, I guess, responding to kind of the thoughts on, pre-production, I think from our experience, and I guess harkening back to your other comment about just a desire for increased collaboration and for our processes to kind of, complement one another and be more closely related. I think we've made a lot of progress in working more closely together. And, there's a number of examples of that. And I think we continue to do that and see this as an opportunity for that. I mean, in terms of pre-production, that we've been, the addition of this consultation process for CDPHE during that, I think has been really meaningful and has resulted in, a lot of reductions in that part of the process, even though it's, before modeling is done. It seems like we've really seen a lot of additional commitments and additional BMPs come into play by operators as a result of that process. And so, I think we could continue having conversation about how do we make sure that's as most successful as it can be, with keeping in mind that we have, one FTE for consultations. So we've really been focused on doing that where we're going to get the biggest bang for the buck, right? And so focusing consultations on those OGDPs that are near RBUs, that are in disproportionately impacted communities, for example. And, we could talk about, is there a better way to capitalize on that, memorialize what the criteria are for, the number of or which OGDPs, are important for CDPHE consultations, so that we're, making sure that we get those reductions in the pre-production process as well.
Well, and I appreciate that, and I'm not trying to discount the current consultation process, but I'm trying to better understand how we can evolve it to better communicate. And one of the big concerns that I have is, while CDPHE is certainly providing certain BMPs that operators should consider, they're provided in a way that allows the operator to choose to implement them or not implement them. And I guess the question that I had asked Sergio, but is, what if an operator says, no, I'm not going to do these things? And what's the hook then to ensure that operator who's proposing an operation inside of the non-attainment area, but perhaps outside of 2,000 feet of RBUs, where we would have some regulatory hooks to require certain things under review of substantial equivalence, or under certain protections within 2,000 feet. But outside of 2,000 feet, when we're just talking about emissions associated with the non-attainment area and the impacts associated with those, there's not clear regulatory hooks to require certain things. And so what happens when an operator just says, no, I'm not going to incorporate these BMPs that you are recommending?
Yeah, well, I mean, right now, we at CDPHE don't have authority to require BMPs, right? We're in a consultation role. That is, we respect very much that role and the role that you all have. And at this point, at the OGDP point of the process, to determine, which things should be a permit condition and which should not, right? So we stay in that consultation role. I think, nothing would. I think you all could have that conversation about, is it appropriate? Is it meaningful to codify those BMPs in regulation, right? For example, to make them, determine which ones, should be required in what circumstances. But I certainly will not opine on that. I think that's, a discussion and decision you all could have. But that's true, right? Right now CDPHE does not have any kind of authority to require BMPs. We are consulting.
Yeah, I mean, I understand that, but I think that's what the ask here is from some of the parties, is that we marry those processes so that CDPHE is able to determine through rulemakings that you're undertaking currently or have undertaken, around NOx thresholds in order to be able to meet certain requirements, to meet certain requirements for greenhouse gases, and ultimately to meet certain requirements for air toxics, and understanding that there's going to be some thresholds that or intensity standards that are developed. How do we incorporate that information into a process where we're permitting things and we're evaluating these two things, and we're looking at different BMPs or different technologies that are being considered, and ECMC wants to ensure that whatever we're permitting is going to meet these standards thresholds and that are being developed at CDPHE, so that we can then codify them in a performance-based type of standard within our regulations, utilizing the data and the expertise that is provided by CDPHE. Does that make sense?
I mean, I think, it makes sense to me that that's the crux of what you all are trying to address. I don't know that I have the solution to offer you of exactly how to do that.
Okay. And so that's where I'm coming at this from, is trying to figure out how that works, because as we look at wildlife BMPs and wildlife considerations and standards that we have within the rules for wildlife, we're evaluating these things utilizing CPW as the state wildlife expert and applying different things and different standards associated with that consultation and different review levels, and that informs our decision making as to whether or not we're ultimately approving things that are protective and meet the mission. And from a CDPHE standpoint, at least from my perspective as one commissioner, that would be my hope as well, is that CDPHE, being the state expert on public health and welfare, that evaluation and that analysis and application of appropriate standards and thresholds that are being developed at CDPHE are part of a consultation that occurs to us, so that when we evaluate that application, we can take that expertise that CDPHE has and determine whether ultimately we're approving something that is protective of public health, safety, welfare of the environment, as well as is going to meet whatever statewide standards we have as sister agencies, as directed by the legislature and the governor's letter on NOx.
Mm-hmm. Yeah, I appreciate that. And I think part of what I, hearing overall is, and I appreciate your kind thoughts or kind remarks on, the value of the consultation process and the value that, the agency brings to you all's decision making, and a desire to look at, how do we build upon that process and bring that expertise the decision making, and would just urge continued mindfulness of, when we talk about building on or expanding on consultation process or otherwise, that it would need to be right within our resources. We don't have, any, resources necessarily. So we need to figure out a way together to build on that, in a way that is actually implementable.
Sure. Well, I certainly appreciate you being here, and I'm certainly not trying to put you on the spot. I'm just trying to kind of frame the conversation, because it's going to be a long conversation that we're going to have here to try to sort some of this out, and certainly appreciate you being here answering questions.
Hey, I appreciate it too. And Commissioner Mesner, my technical folks we're just kind of responding a little bit here to the comments you made earlier about modeling. And I think I just want to make clear that additional conversation would maybe make sense. I think on our end, there is a lot of information and detailed information that's needed for modeling that isn't available at the OGDP stage. So I know you were kind of questioning that, and I think on our folks are saying actually there really is a lot of that information that's not known yet, that would make modeling impossible at that stage. So happy to have more conversation on that, but just wanted to
and I think I think it's a good conversation. Is there things that we can do to evolve what the application requirements are from our level in order to give you the information that you need to do that, if that's determined to be an appropriate path forward? In addition, is some modeling and certain circumstances provided by the operator something to be considered in order to bolster the application requirements in order to be able to provide certain information if that seems appropriate in certain scenarios. I'm not suggesting one thing or another, but I'm saying that I think there's some ways that we can look at it to perhaps make it work. So.
Yeah, well, I think that conversation would be good, and certainly a deep dive with the technical folks. My understanding is, even if we evolved it so that we had that information earlier in the process in terms of what the production part of it looks like, I think it's technically incredibly challenging, and I don't know I don't even know if our folks would feel like they would be able to do modeling of pre-production, and not just because of lack of information, but just because of the sort of nature of the process.
Sure, I think they've indicated that.
Yeah. Okay.
Yeah.
Thank you. And I just want the commissioners to know that you now have the CDPHE letter. We didn't have it before this meeting. Unfortunately, when it was disseminated to Mimi Larson yesterday, it went to her spam folder. So she forwarded it to us after you started talking, Commissioner Oath. And so what I just want to let everybody know is that there's an extensive 7-page letter from CDPHE about all this. It's okay. It's good to have these initial discussions, but I want to remind all of our stakeholders that will be in the record as we contemplate creating straw dog rules. And I would encourage everyone to read it. It's very well done. It has a lot of thoughtful comments about the modeling and when and how and whether and all that. So just wanted you to know, Commissioner Oath, that some of the questions were perhaps not informed by the letter because we didn't have it.
My apologies. Sorry about that.
No problem. Well, we definitely appreciate you being here. I think this is the start of a good discussion as we move forward. And Commissioner McGowan is recognized.
Oh, thank you, Mr. Chair. So I feel like, and granted, you've only heard 2 commissioners today. It feels to me like there maybe are 2 opportunities for our 2 processes to interact, right? One is at the beginning when we're looking at an OGDP, and this kind of, for me, a red light, green light.
Your first stop is San Diego. Proceed.
And whether or not to me, it's similar to the total daily maximum load kind of that you all have for water quality, right? Like everybody's adding to this stream. you've now reached capacity and you can't add more unless something is taken away or you've met a goal. You're at a maximum load, and it's a red light or a green light as to whether or not someone can add something more. And so if we're talking about NOx or greenhouse gases, is there some sort of way for us to interact with you at the very beginning with an operator to say, yeah, we will go through and review this OGDP because there's a green light over at CDPHE. You still have some wiggle room in there, or you're at capacity. We need to have a talk with industry or with the operator on, you know, we're having a bad ozone season. You all are going to blow the cap that we need. We need to do something different. And then I feel like what I'm hearing Mesner say, and what some of our stakeholders have said, is that's kind of estimated stuff. Is there a way then, kind of after we've given it maybe a conditional approval, to your point, there's a check-in then again with you all as it goes through its modeling to get as the operator is getting their permit, that they don't get the OGDP until they pass their permitting process with you, perhaps. Concept. If other commissioners are uncomfortable with any of that, speak up. I'm wondering if it's possible for our two staffs to work together on straw dog rules based on some of the comments that commissioners have given, or do commissioners feel they need to give more specific input into pieces that they want to see in the draft, or how we want to consider moving forward from this point, Chair Robbins?
Commissioner Messner.
Thank you, Mr. Chair. I think Commissioner McGowan, assuming you were asking a question, from my standpoint, you know, certainly I think it's going to be important for technical staff between the two agencies to communicate and see if there's a path forward for some of these concepts. I would like the opportunity, as we initially had contemplated, for staff to be able to individually meet with commissioners, and you know, for us to be able to provide some specificity to perhaps some of our comments, you know, and then staff will ultimately have to determine how to compile that, and whether or not to incorporate it in the draft set of rules that they're developing. But I've got certainly some additional specificity that I haven't really worked through, you know, during the couple of sessions we've had here.
And I will say, you know, from CDPHE's perspective, yes, definitely, you know, happy for our staff to collaborate with ECMC staff on putting together some things on paper.
Others with thoughts, questions? All right, seeing nothing further, thank you very much. We look forward to furthering the dialogue.
Yeah, I do as well. Thank you again for accommodating and wanting to hear from us. We really appreciate it.
All right. With that, commissioners, it's probably sensible to take a lunch break. It is 12:22. Do we want to come back at, say, 1 o'clock and then finish up our OGDP? Let's do that. It's a little more than 30 minutes. 1 o'clock. Okay, welcome back. This is the Colorado Energy and Carbon Management Commission. It is November 15th. It is 1 p.m. We are going to retake up docket 2210000275, a Gunnison Energy oil and gas development plan application. At this point in the docket, we have just finished the presentation in chief by Gunnison Energy, and now we will have a presentation of a case in chief by Citizens for a Healthy Community. So we would look to allow Mr. Foote to be available. And Mr. Foote, if you could call your witnesses to the dais, we will go ahead and get them sworn in to start.
Great, thank you. Yes, we have 5 folks that would like to give remarks. So if we could have Trey Meckel, Cassandra Shank, Brent Hellickson, Mark Waltmeyer, and Natasha Leger elevated, and they can take the oath.
but I haven't been able to locate Brent Hellickson or Cassandra Schenk. If they could raise their hands, I will elevate them as soon as they become available.
Michael, geologist, I swear to tell the truth.
Thank you, Mr. Meck. You anticipated where we were going with this. So yes, we'll just go one by one and I'll ask each witness to raise your hand, state your name, and that you swear that to tell the truth. Any luck elevating the remaining panelists?
I have not seen them in here yet, unfortunately. If we do here, I will make sure to elevate them immediately. Oh, I see Shank in here, excuse me. So we're just waiting on Hellickson, and I will notify you once elevated. All right, we'll proceed while you do your elevating. I'll next go to Ms. Leger.
Natasha Leger, Citizens for a Healthy Community. I swear to tell the truth.
Thank you. Mr. Waltemeyer?
Mark Waltemeyer, Valley Organic Growers Association. I swear to tell the truth.
Thank you. Ms. Shank?
Cassandra Schenk, CS Services, and I swear to tell the truth.
Thank you. Mr. Chair, I defer to you, but perhaps we can always swear in the final witness when it's time for them to appear.
Is that work for you, Mr. Foote?
Yes, apologies. I think all of our folks were aware we start at 1, so I'm not sure what happened there, but I'm assuming that he'll be here.
Okay. Well, if you want to proceed with your case in chief, the floor is yours.
Great. Thank you very much, Mr. Chair. And just to give you and the commissioners a roadmap of our presentation in chief, first, we'll ask that you'll hear from Trey Meckel. He's a geologist with over 30 years of experience and will focus on the geological hazards issue. Then we'll ask for you to hear from Cassandra Schenk, who has almost 2 decades of experience as an environmental consultant and who also serves as operator and responsible charge for 5 domestic water systems around Paonia and Hotchkiss. And she'll talk about water contamination issues and is available to talk about wildlife issues if necessary. Then we'll ask 2 individuals to speak on behalf of the local organizations which would be significantly impacted by adverse events from this oil and gas operation, and that's Brent Hellickson of the Terror Ditch and Reservoir Company and Mark Waltemeyer from the Valley Organic Growers Association. And Natasha Leger, who is the Executive Director of CHC, is available for any questions in addition to what you'll hear from the 4 witnesses, and those witnesses are available, of course, as well. I would just specifically ask that she be called on in Q&A to help answer Commissioner McGowan's question related to Delta County notifications that was discussed a little bit during the operator's case in chief. Mr. Chair, hopefully we'll have all of those folks elevated. It sounds like we've got at least 4 out of 5, and I will just first turn it over to Dr. Meckel for his part of the presentation.
Thanks very much, Mike. I'm going to speak for briefly concerning specifically the geohazard analysis that was submitted to the commission for review as part of the application. Also make some supporting statements. I'd like to share my screen if possible to assist in the comments that I'll make. Can you see my screen? I don't.
Yes, we can see it. It's not in presentation mode, if that makes a difference.
How about now?
We still see it. It's still not in presentation mode.
All right, let's try. I'll just zoom in. It doesn't matter particularly. There's no animation. About as large as I can make it.
That works.
I'd like to start off just by reviewing some of my professional qualifications. Mike mentioned that I'm a practicing geologist with more than 30 years of experience, specifically in petroleum, but also in renewable energy and sustainability. For most of my career, 27 years, I've been in senior leadership positions in global super major independent and private oil and gas companies, specific to exploration production, with extensive applied experience in multiple national and international jurisdictions, allowing me to speak with some authority on the matters in hand. Presently, I'm involved in geothermal energy projects and carbon capture and sequestration projects in both the United States and Australia, which involve comparable permitting, certainly allowing me to comment with authority. I'm also a subject matter expert in decarbonization and industry sustainability, with numerous professional affiliations and involvement. And finally, I'm a Colorado taxpayer with roots in the Uray area for the last 55 some odd years, presently based in Melbourne, Australia. What I'd like to do is review quickly some of the deficiencies I observed in the geohazard assessment specifically, and then some additional risks or hazards that I think ought to be addressed by GELLC or Gunnison in their analysis on a go-forward basis. Some context, I would suggest to the Commission that the relevant past history suggests an abundance of caution is advisable, recommended, and necessary. Within the county, there have been 5 state and federal landslide and flood disaster declarations and natural geohazards in the last 50 years, but those don't include similar declarations in surrounding counties and locally significant events, as I'll mention. Specific to the oil and gas industry, there have been 12 spills or releases from local wells since 2018. And 26 since 2006. In my experience, that's a significant number of spills. That's non-negligible, regardless of the total number of wells. Specifically, Gunnison was responsible for 9 of the 12 spills since 2018, and 17 as available on the ECMC website, and 17 of the 26 since 2006. That indicates to me a risk that the risk for a future spill is highly likely. And although the operator has maintained that the spill data are statistically insignificant given the small number of wells in the region, I would argue that they pertain specifically to the operator's performance in the area of interest being considered, and so are very relevant. My observation in reading through the geohazard assessment specifically is that Gunnison haven't provided an evidence-based, verifiable quantification of geohazard risks. They've dealt largely with qualitative statements of risk and looked at risk mitigation on that basis. In general, I think a reasonably acceptable standard would involve a risk matrix. And I'd point out also that their assessment is inconsistent with other sources, publicly available sources. In the table, I've outlined a number of risks that were identified in the geohazard report: mass movement, natural seismicity, expansive soils, subsidence, and flooding. Gunnison basically assessed, or Gunnison's contractor basically assessed all of these as low risk, not significant risk, moderate risk. I don't know what those mean. I have no basis for assessing what a low risk is. Is a low risk something that doesn't happen very frequently? Is it something that isn't terribly doesn't have terribly disastrous consequences? It's not clear to me. What I'd point out is that if we just take the Delta County Hazard Management Plan, most recent one published in 2018, it's currently under review at a broad scale, so for the county, or specific to the pad location in the right-hand column. I've highlighted it in red. Some queries I've got. If mass movement risk is low in Gunnison's assessment, I'd point out that there have been a number of mass movements, largely avalanches, but also including landslides just south of the location on Highway 133 in the last decade. And the county actually identifies a high susceptibility for landslides in the specific area with a map to document that susceptibility at the drilling location. Natural seismicity, low. I tend to agree. However, I'd point out that the map provided in the documentation shown on the left indicates a large number of not insubstantial earthquakes in locations with extractive industries, largely associated with those coal adits in the orange lines. But you're looking, the yellow dots and orange dots are all earthquakes with limited superficial damage, but that purple square within the 1 mile radius is an earthquake that on a damage scale incurs light structural damage and so might impact operations on site. And that's in the historical past. If we look in a forward sense, I found a representative insurance evaluator's estimate of earthquake risk in Delta County, and it suggests that at a meaningful occurrence, a 2% probability in the next 5 years, the expected earthquake will be on the order of a 6+ magnitude, which would cause considerable structural damage. Same applies to expansive soils. A low qualitative assessment by Gunnison compares to a probability of it occurring at least once a year in Delta County, and Delta County also noted that the prevalence is much higher in the northeastern portion of the county. And then with subsidence, we know in the recent past, just a few months ago, there were sinkholes and washouts along Highway 133 associated with subsidence and runoff. So in conclusion, in my experience, best industry practice is to explicitly quantify the risks associated rather than qualify. And in addition to quantify the planned mitigation activities, which I feel is substandard in the application. Looking at a few other deficiencies that I think really ought to be considered, and I found no documentation, or I was provided no documentation that would have allowed me to review these in more detail. But induced seismicity, drilling losses, watershed impacts, potential for a fire or explosion at the facility, or wildfires in the region, are all significant and should not be neglected in any analysis of risk. I'd highlight that in terms of drilling losses, the operator states that they expect losses to be at least 100% of the minimum calculated mud. That's into the subsurface, and there's no plan to monitor or remediate those losses. In terms of fire or explosion at the facility or wildfires and their potential impacts on the facility, there's no analysis that I'm aware of. Despite the fact that with respect to fires, there have been 7 local fires in Delta County since 2008 with an area of greater than 10 acres. So what do I have in mind in terms of that best practice I mentioned in the risk assessment matrix? This is one that I've used extensively in the last 5 or 8 years. It's very quantitative, and as you can see, I'm not going to go through all of the words on this slide, but we look at both the likelihood of a risk in terms of it's down the left-hand side at the bottom left. Its occurrence. So whether it occurs in this case, we've looked at quarterly versus yearly versus every X number of years, and then across the horizontal axis is the consequence in terms of safety, environment, the financial impact to the community and to the business, community and reputational risk and compliance. And what you can see is there's an overall movement from lower left to upper right in terms of how risks might be quantitatively identified from very low to very high. And I'll discuss what might be done in each of those instances. But you can see, for instance, that a medium risk here might be anything from almost certain to a very remote possibility of occurrence, with anything from minor harm to multiple fatalities. So simply saying that something is a medium or a low risk doesn't tell us really what likelihood something has of occurring or what the potential impact is in order to know whether it's something that ought to be addressed or not. Why does all that matter? The risk matrix and the mitigation plan to address those risks provides the essential framework to demonstrate the prevention of and protection from adverse impacts. Now, Gunnison has provided a mitigation plan, and I commend them on that. I would just simply say that we have no basis to really evaluate what the risks are and whether the mitigation is sufficient. The risk mitigation and risk matrix and mitigation plan provides an evidence-based description of prevalent hazards and describes and quantifies how those may affect relevant population, property, and environment. The matrix itself is unambiguous, it's transparent, it's consistent, and it's auditable. Those are all critical factors in terms of understanding what the risk is to further development or future development. Mitigation plan identifies specific, measurable, actionable, realistic, time specific activities that avoid, minimize, and mitigate negative outcomes. And then in comparison, a post-mitigation risk matrix shows how your mitigation plan is going to reduce those identified risks to acceptable levels. Without those elements in place, the required duty of care for a license to operate can't be assured, and the project really shouldn't progress. I wouldn't progress as a senior leader within a company. I wouldn't progress any project without that as a minimum expectation. I'd also look for some consideration of worst case scenario planning, because no amount of mitigation preparation can prevent the disasters from occurring 100% or eliminate the risks. Importantly, a properly implemented RMNP saves lives, it reduces injuries, it results in reduced property damage, it protects the environment, and it allows meaningful stakeholder engagement on a specific basis. Finally, what I'd like to say is what can be done to rectify those observed deficiencies I've noted. On the left, if you look at those quantified risks and the associated mitigation plan that might be undertaken, anything falls into a high or very high category, regardless of its frequency or its consequence, is an unacceptable risk and ought to be avoided, or in the case of high, minimized while undertaking mitigating actions. So altogether avoided or minimized if it's a high risk that is on its way to being reduced. A medium risk is undesirable for sure and ought to be mitigated and managed to as low as reasonably possible. And then low and very low risks require monitoring and in particular demonstration that nothing is rising to medium or higher levels. Once you've gotten all of your risks into a medium to very low category, you'd follow a process of an explicit process and very well laid out process of measuring, monitoring, and verifying your results by determining and disclosing metrics to be measured, establishing, in this case, conservative baseline conditions that address the worst case scenario. As examples, Gunnison have already collected data from their historical operations vis-a-vis microseismicity and emissions data, as already discussed. Compiling relevant analog data from nearby and regional activities throughout Colorado, and performing new surveys if required. And here I'd point out the NSAR survey is probably a good baseline to use, but really needs to look at a larger area that might impact with respect to landslides. By monitoring, there's an agreed minimum reporting threshold and the schedule of reporting, and then tracking and disclosing relevant temporal changes ray the baseline. And then finally verifying by providing audited public reports at agreed frequencies and communicating revised risks and mitigation activities transparently. Thank you very much. I'm open to questions.
Thank you, Trey. And I think the Q&A will be at the end. If we could turn it over to Cassandra Schenk, that would be very helpful. Thank you.
And Mr. Foote, did you note the time from the chat?
Yes, I did. Thank you.
Okay. Commissioner Cross, did you have a question?
I'm just wondering if it might make sense to ask questions of each witness rather than asking questions at the end, so we can. So
It's fine. It's fine with me. Go for
it. I don't know if we want to look to the operator first for cross-examination before, or if.
Well, maybe since I screwed it up the first time, let's just keep going in that same general direction and hear from all the witnesses. Let the operator cross, and then let's ask questions. There's only 10 minutes left of presentation at any rate. Okay, so Mr. Foote, your next witness.
Ms. Schenk, please.
Ms. Schenk.
Good afternoon. It's an honor to be here today. In the interest of time, I'm just going to jump in here and make a few points. Admittedly, I haven't been paying attention to oil and gas development in my community for about 10 years. I've been working as a consultant, and just for conflict of interest, I just focused on my work, but I did jump in and took a quick look at this application. I do have a background also in environmental risk management, and I just wanted to share that over the 16 years that I've been here, I've observed some real substantive facts that I believe is important, that makes the case that this is a unique place in the state. So what you see on my screen right now is the topography of Colorado, and particularly the central to western part up to the Utah border. So I'm going to circle the largest flat top mesa in the world, which is right here.
I don't believe we're seeing your screen if you're planning on.
Sorry. Okay.
Okay, now we can see it.
Yeah, I just want to point out that this is the largest flat top mesa in the world, and it is adjacent where it intersects with the Rocky Mountains, is why this is such a geologically diverse area. You can see the point that's in red. That's approximately the point where the drilling would occur, the additional drilling. And then let's see if I can get my screen to move down. So, as someone that works with water, one of the things I've noticed is, first of all, why are there so many organic farms here? Why is this the highest concentration of organic farms in the nation? Why is the infrastructure here so intricate and intense? I've had to make this case at the state level to the NRCS. I worked on the Lower Gunnison project. Our area is riddled with irrigation infrastructure and small niche organic farms. The reason is, I believe, the underlying geology and the topography, which is very unique and distinct in the state. So here's a couple facts. Just recently, last year, I was talking to KCK. I was being audited by him, and he said, oh my gosh, we're talking about the town of Paonia water system, which is state famous for failure. And he said, it's the most complex statewide. My experience as an operator, I've lost millions of gallons through a 10-inch main that did not surface. And this is in the LaRue Creek Canyon. The topography is intricate and fragile. As we've discussed, here's the geological hazard map. My question would be, how is 1 mile adequate? I mean, looking at risk subsurface, adding liquid to the subsurface environment in this amount, where we have this amount of development from historic mining, we have this much activity. Does this make sense? So what's really going on here? I'm scrolling through, what happened last year. These hazards are real. So when I look at, from an environmental planning perspective, what's the scale, scope, and intensity of an action? I look at quantities, I look at distances, and these are just rough numbers, but if we're to take those 12,000 feet of subsurface activity in different shapes, we'd be at 1,400 acres to 3,300 acres. That gives you some sense for risk, subsurface. We're looking at production at any one point in time between 50 and 100 million gallons of product held under pressure subsurface, susceptible to some of this activity. And what's the time frame? It's 30 years. That's big. So what are these downstream receptors? What we've got here is the confluence of Cottonwood Creek with Hubbard Creek. If something is on the surface, that's one thing. If it's subsurface, how long is it going to take to get detected? We have enormous fluctuations in this watershed. So this is Hubbard Creek. You can see from 1 CFS to 1,000 just last year. So this area is very susceptible to weather events. The soils are erodible. Their water transmissivity levels are low. Their capacity to handle a spill is really not there. The downstream receptors are not just the normal wilderness receptors that you know of, amphibians, birds, wildlife, but it's this rare and unique agricultural community. So what's on the screen, it shows you the cluster of organic farms. So I'm going to give you some statistics. By far, this is the highest concentration of organic farms in the state. Delta County has had 54 according to 2013 ag statistics. Boulder County, imagine Boulder County was next at 36. Mesa County at 12, and all other counties statewide were within 4 or under 4. If you just look at linear miles of maintained ditch, 279 linear miles of maintained ditch in the Hotchkiss-Paonia area. As we move out of this special area where you have the confluence of these major landforms, you get to Surface Creek, which has 89, and Delta, which has 69. So it's very intricate here. Rogers Mesa Research Station is devoted 100% to sustainable ag, and there is no other such land grant institution known nationwide. So, you know, if we look at some of these things that could be incorporated into risk, let's look at the timing of a release. You know, we're looking at in the order of 1.2 hours to 11 hours, depending on flow, for something to get to these gates. These are the 5 irrigation takeout points. This is the miles from Cottonwood Creek, from that confluence, from that point that I showed on the screen earlier. If we're looking at these kind of flow rates, are we really prepared? Do we really have the notification process ready? Are we really understanding and addressing risks? I skimmed through the notification procedures. I think they need to be refreshed and looked at. So in conclusion, the application, I really appreciate all the work they put into it. I do feel like because we have this confluence of probability and consequence that's unique, that we really need to stop and look, does this make sense? This watershed is fragile. It's uniquely fragile. It's poorly understood what's going on subsurface. If we're going to have this quantity of potential contamination in these headwaters that feed this area, is this something we really want to do? So the application, approving the application would add on to this probability side of the equation. We know there's been oil and gas development already here. This would add to it. So looking at risk, I think, is really important. I'm asking you as gatekeepers to please see this rationale and consider it. And I really appreciate your time today. Thank you. Sorry it was so short. Nice to meet you.
Thank you. If we could call Brent Hellickson next, please.
Mr. Chair, we'll need to swear Mr. Ellickson in before he begins his testimony.
Right. Go ahead.
So Mr. Hellickson, I'll just ask you to raise your right hand, state your name, and that you swear to tell the truth.
I'm Brent Hellickson, and I swear to tell the truth.
Thank you.
Go ahead, Mr. Hellickson.
All right. So my name is Brent Hellickson. There's my contact information. I'm the secretary of Teradition Reservoir Company and the owner of Stone Cottage Vineyards and Winery. So I am served by that company as well. And I'm going to keep this short. I just want to impress upon you why Teradition Reservoir is concerned. The Teradition Reservoir Company has water rights dating from 1884. We serve between 40 and 50 users in Garvin Mesa. Our watershed is adjacent to the Gunnison Energy proposed operating site. Portions of the ditch have been in infrastructure have been in continuous operation for 130 years. The reason we're concerned is that Gunnison Energy has chosen to attempt to operate in a pretty difficult geological area. Artificially induced seismic activity from drilling and hydraulic fracturing and wastewater operations are our primary source of concern. We have ditch infrastructure, a reservoir, and a Class 1 dam adjacent to the expected extent of the horizontal portion of the proposed wells. We have a slide directly above and adjacent to the reservoir that has shown movement in the past. We've been monitoring it for several decades, and we have it stabilized, so it's not moving currently. Portions of our ditch system have slopes above them that exceed 80 degrees, making them extremely vulnerable to seismic disturbances. And we have noticed that some of the seismic events associated with nearby coal extraction have increased rockfall in the ditch, requiring additional maintenance. I'd like to correct one bit of information that the operator put out there. The Bowie number 2 mine has mined directly adjacent to and underneath Terror Creek, has crossed Terror Creek underneath it, just north of our takeout point, and has mined on the other side of Terror Creek, the west side of Terror Creek as well. So any interruption in water during the irrigation season, as many of you know, is critical. And it would result in unsustainable losses to the farms and ranches on Garvin Mesa. Many things that could happen here due to the seismic activity would result in repair expenses that Terror Ditch and Reservoir just simply could not support. The slide above the reservoir, damage to or failure to the dam. The threat of damage to the dam has in the past increased our liability insurance costs, and that could possibly happen again if it appeared that seismic activity was involved. Increased seismic activity may cause the failure of our ditch, which we could not support as well. And it almost certainly will result in increased maintenance costs. So the application does not contain solid data analysis that would allow the quantification of risks that we are being forced to absorb. And therefore, it does not address TDRC's concerns. Thank you for the opportunity to speak.
And Mr. Chair, if we have time left, would like to be able to call on Mark Waltmeyer from the Valley Organic Growers Association.
Yeah, you're past time, but I'm keeping track of the extra time, and we'll make sure that we are being fair to both sides here. So go ahead. Let's hear from Mr. Waltmeyer.
Thank you. I appreciate this opportunity, and I'll go as quickly as possible. I'm a Valley Organic Growers Association board member and a farmer here in the North Fork Valley. I have been for 18 years. VOGA represents over 130 producers, almost all downstream of the proposed expansion, and most reliant on irrigation water from the North Fork of the Gunnison. What we perceive as risks are first the direct contamination of our irrigation water and subsequently our land and produce, and second, damage to our reputation as a source of high quality fresh food produced responsibly and with the health of the land, the producers, and the customers in mind. A spill upstream, whether or not it contaminates a field or the food derived from that field, would substantially destroy our ability to market our food. And it's a reputation that we've worked for decades to build. I'd like to touch on the notification a bit. I get my domestic water from the Hanson Mesa Domestic Water Company, a volunteer board run domestic water company. We had several outages over the past couple of weeks, and I was effectively notified while traveling by email and text with time to call back to the farm to prepare for storage and for contingency plans for washing produce. I don't see a notification system for a spill as being onerous or even difficult, and it would give growers like me a chance to turn off pumps, shut down a head gate, or otherwise prepare. It would also go a long way to build trust between those of us who would be adversely affected and the state agency whose mission is to protect us. Accessing information through the ECMC website does seem to me to be onerous and an unnecessary burden. Those of us affected should not have to take on the extra effort. Likewise, we shouldn't have to rely on the county to pass the info on. The info should be reaching us, and we shouldn't be having to seek it out. Thanks for your time.
And Mr. Chair, that's the conclusion of the witnesses. We really appreciate your grace for a little bit of extra time there. They stand ready for questions, as well as Ms. Leger, who could answer questions, particularly about the notification issue that came up earlier. Thank
Well,
you.
why don't we have Ms. Leger answer the question about the notification issue just to start with?
Good afternoon, commissioners. Can you hear me and see me?
Yes and yes.
Oh, wonderful. So to address Commissioner McGowan's question about Delta County offering some notification to the community, it's important to note that Delta County currently does not regulate oil and gas regulations, oil and gas, and they do have a local government designee. However, even though that LGD provides reports to the commission, and I would say specifically one commissioner, that is not shared with the community or the public or on their website. As an advocacy group, we have had to do public records requests in order to find out what's going on relative to oil and gas in Delta County. So from our perspective, at least right now, the county is not a reliable source for sharing that information with the community. Thank you.
Okay, thank you for that. At this point, Mr. Foote, before we dive into commissioner questions, Mr. McGowan does have the opportunity for cross. I don't know if he plans on doing that or not. You're muted.
There we go. Can you hear me now?
Yeah.
Sorry. No, Commissioner, I don't believe we have any questions at this time. Thank you, sir.
Okay, great. Commissioner Cross, you had raised your hand at the beginning of this. Do you want to go first?
Sure. Thank you, Mr. Chair, and thank you all for your testimony today. If I could, maybe it makes sense to start with Ms. Schenk. I guess I want to start with, you were talking about some of the releases there. And could you just clarify, are you talking about a release of water, or are you talking about a release of production?
Domestic water.
Okay, and you're talking about the release of domestic water from the tanks. I guess, could you just clarify a little bit more what you were trying to do?
The point that I was trying to make was how difficult it is, and any drinking water operator that works in this area understands how difficult it is to predict what's going to happen subsurface. So we lost out of our 10-inch main millions of gallons of water that did not daylight. We wouldn't have found that leak except for an air relief valve that we knew about and we could look at. So that was the point of that.
So you're worried about water that's being used in the drilling process spilling, but not even being noticed.
Exactly. Subsurface releases that aren't noticed.
And what are you defining as subsurface there? I know you mentioned, like for example, how far was the 10? You said the 10-inch.
Yeah, it was 6 feet down.
And do you have an idea of what the depth is that the operator will be doing here?
So the flow lines are, I'm not sure what the depth is. I don't know if the depth is, to me, pertinent, because the topography is just so varied. And I get that was the point I was trying to make, was that how
what you're worried
liquid
about is the flow lines, not the actual drilling that's got the subsurface casing.
Okay, yeah.
Okay, so but the flow lines is what you're worried about.
I'm worried about any liquid going subsurface, any liquid that's being transmitted subsurface, the producing of the wells, and then and once the wells are put into production, how many miles of, I'm trying to remember, it's 12,000 times 6, however many miles that is of new subsurface product that's being held. And if there were to be a breach or something were to get released, it could show up, downstream. It could show up, it might not surface.
Okay, and this is helpful. I just wanted to try and make sure that I understood, because I wasn't sure if you were talking about flow lines, if you're talking about in the well itself with the surface casing and it leaking to the surface from there, or maybe not leaking to the surface there. So really trying to understand where you were going with what was leaking. So I appreciate it.
It's just the probability, potential risk was what I was pointing out.
Thank you. And perhaps we can turn to Dr. Meckel next. And Dr. Meckel, I think it might be helpful if we can pull your presentation back up, because I wanted to talk about some of what you had in there. So if we could go to, I think it, and I'm sorry, I didn't have a copy of your slides here. So but I believe it was the third or fourth slide. So I guess both this slide and the next slide as well. So one of the things I wanted to understand here is, as you have the table, you're talking about the Gunnison Energy Assessment, the Delta County Assessment, and then the third assessment as well. And so, and particularly as you looked at the not assessed, could you go into detail again about what we're looking at here in terms of this application versus, you know, how Delta County analyzed it, how it was analyzed previously? Could you just go into a little bit more detail on that? And you're muted, I'm sorry.
Thank you. The last two columns that read Delta County Hazard Management Plan and IPU Lower 1291 are basically extracts from the publicly available management plan for the county, and observations I make from that report that are specific to the area in question. So those two columns are from the same report. That management report is currently being updated in 2023 and has not yet been released. The more time appropriate version. What I point out though is that Delta County, looking at the entire county, see a substantially different risk, but also are much more quantitative in the sense of what they're providing as the assessment of their risk. They talk specifically about the frequency of occurrence and the impact of that occurrence within the report.
Okay.
That, I would argue, is best practice. What I'm pointing out, highlighted in red throughout the two columns, is where their observations at the county level and or at the site are inconsistent with Gunnison's own assessment of the site. So you have an independent assessment that suggests a high susceptibility for landslides exactly at the location of the site. And in fact, I can show you that very quickly. This is the landslide susceptibility map. The little circle right here, if you can see my cursor on the county line, is the location. It's in blue, so it has a high susceptibility to landslides exactly in the area. It's surrounded by very high susceptibility landslides. Likewise, wildfire is in the high intensity to highest intensity region throughout the county. Those are quantitative estimates. I can hang my hat on that and say what I think the associated risk is on that basis. Simply calling something a low risk doesn't help me, and certainly doesn't help me in terms of developing a sensible mitigation plan. Am I mitigating against the frequency or against the magnitude?
Okay, and you mentioned wildfire there, and could you go into a little bit of detail? I know you talked about the fact that wildfire was not addressed in the geological hazard plan. Could you go into some explanation as why you think that should be included in the geologic hazard plan?
I don't think it should be. I think Gunnison have correctly identified what qualifies as a geologic or a geohazard. That's a fairly unambiguous definition in all regulations and guidelines. What I'm arguing is that a holistic risk assessment for the location ought to consider the risk of a wildfire that would impact the facilities. If you have a fire that's burning in that area and you have oil and gas under compression, imagine the magnitude of potential risk associated with that.
So here the issue is not necessarily their geologic hazard plan, but rather ultimately what they're proposing in terms of mitigation measures.
That's correct. And that's why I've put it on a separate slide. It says other possible deficiencies. I'm not aware whether they've addressed that. I would hope that they have, and certainly discussed it with their insurance company at the very least. But I've not seen anything that identifies that as a risk to the development. It's an external risk. It's not a geological risk, but it is a geographic risk. And it's not an insignificant risk with a number of local fires over large areas throughout the county.
Okay. And if you could go to the next slide as well, and one of the things you said is that it's necessary to provide a quantitative rather than a qualitative. And can you go into a little bit more detail as to how this is quantitative? Because ultimately, as I'm looking at it here, I see some specific numbers when it comes to potential financial impacts. And here I know you have it listed in Australian dollars.
Yeah.
But I'm not really seeing the quantitative.
I would point out these tables we build them separately for each individual project. So these numbers apply to a project I was recently involved on. I wouldn't argue that the financial cost is at all relevant here. You might want to use one might want to use different numbers, and what the company and you agree to is between yourselves. In the other ones, though, for instance, let's just look at environment or community reputation, but under environment, if I'm looking at consequence, what I can see is that if I can talk about the impact to the surface or groundwater under minor harm, consequence 2, if I quantify that and the number is greater than 0, then I fall into a minor harm. Or is it happening over a larger localized area, say within the 1 square kilometer radius? I'd call that a moderate harm or consequence 3. If the surface water reached Paonia or down to 133, I'd look at that as severe harm, large scale impact.
And I guess just to stop you there for a minute, I'm kind of wondering where the quantitative analysis comes in here, because ultimately what I'm seeing is, again, the qualitative analysis that you just criticized with Gunnison Energy, talking about low risk, medium risk, moderate, high. And so here I'm
no. So sorry, let me correct you on that. Let me correct you on that. The definitions here describe, yes, qualitative numbers, but they must be underpinned by the relevant quantitative number. In other words, if I say I'm in a D3 risk, which would be what would that be? That would be medium risk, right? And I say that I have moderate impact. I'd want to have a quantification of what that environmental impact is to be able to defend the fact that it's moderate and not large or minor. So do you have underpinned by quantitative numbers to support their categorization?
So you're saying that ultimately what you're saying is they need to have something that says, if this was to happen one time a year,
the impact would be X in terms of its environmental impact, in terms of its groundwater impact, in terms of how long closure might take place. Again, if I refer to the Gunnison plan, the county plan, they use different definitions. It was development for their emergency response planning. It would require modifications for Gunnison to use something like that. But here's the probability: less than a 1% annual probability, a 1 to 10% annual probability. And in terms of minor, it's very few injuries. Well, how many is very few? Is very few 1? Is it 5? Or is 5 a minor minor injuries, or the multiple deaths and injuries? So it's a quantification that we can all then look at, agree on, and determine whether the mitigation is sufficient for the risk.
So do you have suggestions for what Gunnison should have used for the quantitative numbers, or is it more so just a methodologically?
I could certainly provide my thoughts on those numbers. I wasn't asked to do that, but that's what I do for a profession.
Okay. And then
Gunnison, reach out to me afterwards if you'd like some specific advice.
Okay. And do you have specific issues as you looked through and I guess we'll start this way. What materials of Gunnison's application did you review?
I reviewed the geohazard management plan, the waste management plan, and the synthetic and oil-based plan that were associated. Other documents weren't provided for my review.
Okay, and in looking through those plans, did you see any best management practices that you agreed with, that you disagreed with, that you thought were the right direction, or?
Yeah, let me be clear. I think that they did a very good job. In terms of a lot of the work they did. I'm particularly would highlight the INSAR study over a much larger area than they're required to do. What I would say is that, as pointed out here, that INSAR data provide a great baseline for future analysis. Now the question is, quantify what the magnitude of a slip might be, and then how frequently are you going to be repeating that INSAR survey in order to determine variance from a baseline. So I think that proactive approach that Gunnison has taken is great. What it does is establishes a line in the sand somewhere earlier this year or in the past couple of years, whenever the survey was taken, that can be used to establish what the conditions are today. That doesn't assess what the future risk is.
Okay.
It doesn't quantify what the future risk is, and it doesn't say how they're going to monitor it to see if that risk is increasing or decreasing.
Okay, and I understand that part, but I'm wondering with respect to the actual best management practices that Gunnison has indicated that they'll agree to with respect to their operations.
So the actual mitigation plan?
Yes.
I would say that what I would want to see is that risk table to understand whether the mitigations are sufficient to address the specific nature of the risk. Is the risk, again, if I go back to my table, and I look at, even if I accept prima facie on face value the assessment of low risk, all those green bars, am I looking at something that's got large scale environmental impact and severe harm across the board with an unlikely occurrence, or am I looking at something with negligible harm but is almost certain? In the first instance, I need to manage that. In the second instance, I might need to monitor it. So the best management practice would be fit for purpose relative to whether something is an F1 or a A4 on this table.
Okay.
You follow me?
But in terms of the actual efforts that they would be taking, do you have any issues with that, or is it more so, again, methodologically, are you looking at the way in which they approached when the best management practices will be applied?
Oh, I think the best management practices are a great first start. And again, kudos to them for being very specific in terms of the actions that they plan to take. I didn't see the full specific measurable and time specific nature of those that I'd like to see. In terms of what frequency are they going to be doing these mitigation efforts, specific to what risk is the mitigation, how is it measured, how is it reported. But in general, it's a very good start, as is the identification of the major risks. I don't think I have any quibbles with either of those. I just think that it's very difficult for you as the commission, for regulators, for auditors to understand if something is a low risk, what needs to be done with it. Is a low risk, a singular oil spill or contaminant spill of 100,000 gallons of fluid, or is it a mini spills of 1 gallon? Those have very, very different mitigation plans associated.
Okay. I think those are my only questions for now. Thank you.
You're welcome.
Commissioner McGowan.
Thank you, Mr. Chair. Thank you for Mr. Meckel. I'm having trouble connecting dots, so bear with me here. It from a high level perspective and reading through the materials and listening to Gunnison's testimony, I think that in their opinion, they've done a risk assessment and the risk is very low based on the assessment that they did. And I think what I hear you saying, that's a good baseline, but they need to do more. I'm not sure what
it's a good starting point. I wouldn't even call it a baseline. It's, you know, they've got it, but again, look at this matrix. Is the low category this one here that I'm highlighting an F1? Or is it an A4? And to you, that's very significant, whether we're talking about the potential for deaths or large scale impacts that have the potential for charging people with an offense and a penalty and a fine versus something that has little or no impact, but is almost certain to happen.
Okay. I don't think our rules require a risk assessment matrix with high, low, medium, whatever risk. And so an operator gets to choose how they present risk to the commission. And as part of that presentation, they include best management practices. So there's a stormwater management plan. In this case, there's a geologic hazard plan. Those plans are submitted as part of trying to show what the risk might be and then the measures to take to avoid, minimize, or mitigate those risks. And so I guess what I need to understand from you is where you think the deficiencies are in those plans, because that's how they chose to represent risk to the commission. And yes, the operator has spills. I think almost all of our operators have spills. Some of them are small, some of them are not. What is the risk associated with that? Where do you see the deficiency in their plan to contain spills, for example? I'm just having trouble. I understand what you're saying, but I'm having trouble connecting it to what Gunnison turned in as part of their materials.
Well, for starters, I would argue that what I'm showing here is what I would, as previous vice president of companies, require my teams to present. I'm not saying that you have the same requirements, but in terms of best practice that I've experienced across multiple jurisdictions, this is minimum standard. It's certainly what we're doing for our geothermal activities in Ridgeway and Texas. It's what I'm doing here in Australia, is presenting it at this level of granularity so that the mitigation plan can be assessed with respect to all aspects, all quantitative aspects of the risk. At this point, if I go back now to this table, you know, the risk of natural seismicity. Let's just take that one as an example. Now, let's use expansive soils or subsidence, because subsidence happened earlier this year, right? We know that we had a sinkhole washout. That's likely to be associated with all those coal mines down to the south along the highway, but in any case, we know it's happened this year. So whether or not that's a low to moderate risk, in what way is it low to moderate? Is it low to moderate because we're far away from the coal mining and the frequency of occurrence is going to be much lower, or is it low to moderate because if it happens, it's going to be over a square foot? The mitigation is fundamentally different for that, and I cannot say that the absolute mitigation plan for the geohazard subsidence is sufficient, and neither can you. All you can say is they've got a plan to deal with subsidence at some level of activity.
Okay, thank you. And my next question, I think, is for Mr. Walter Meyer, I think. Valley Growers Association, correct?
That's correct.
Thank you. So your point about the reputation of your product and wanting to, assurances that other things that might be happening in the area don't affect, you know, your ability to sell your product and represent your product. There's already oil and gas activity in the area. There's a site adjacent to this proposed site. I guess I'm trying to understand how you can say that this additional application is the thing that could affect the your company's visibility or how it's viewed, versus because there's already oil and gas in this area, in this location. Do you see?
Yeah, it's true that I do see what you're saying. I think additional oil and gas activity ups the risk to us. I think additional risk is something that we want addressed, and I think that we haven't seen anything to reassure us that the risks are being addressed and that our concerns are being addressed. And we'd like something different.
Thank you.
Mr. Merkel, you have your hand up. Did you want to answer something?
I just wanted to clarify my answer to the first question, if I might, regarding the mitigation. The fundamental observation is that the mitigation plan is to protect corporate assets in the eventuality of a geohazard occurring. It has nothing to do with whether or not the geohazards might also impact the environment. That I think is a critical factor in terms of how the mitigation plan might be fundamentally improved prior to any consideration of approval.
Thank you. Further questions for the panel? Okay, I'm not seeing further questions. Thank you, Mr. Foote, for the presentation. And with that, we will turn to a response presentation by Gunnison Energy.
Thank you, Mr. Chair. So I'm going to have Ms. Donahue pull up our rebuttal slides. And while she does that, I will let you all know that we put these together based on CHC's pre-hearing statements. So we are actually going to go ahead and answer some of the questions that they may not have gotten to, and we hope that may be beneficial to this commission as well as addressing your question earlier in the day, Mr. Chairman, about the inconsistencies, and then finally, we would like Mr. Levine to address a question from Commissioner McGowan. So in our rebuttal hearing, next slide, please, Ms. Donahue. So, sorry. So the issues raised by the parties in their pre-hearing statement were geohazards, as you heard some testimony over today, wildlife concern, spills and releases, and alleged application inconsistencies. We would like to go ahead and address each one of those four aspects. With respect to geohazards, as noted before, there was a landslide study of the area west of the working pattern surface. We can confirm geologic events and seismicity that caused damages to third parties and Gunnison's insurance policies. In other words, we can confirm that we are in compliance with insurance requirements under ECMC rules. Installation of seismic monitoring of production wells. We did note that there is geologic data publicly available at the USGS. We would encourage anyone to use that at any time, and then obviously they can reach out. Notification within 24 hours of slope movement. Our concern there, of course, is twofold. First is putting in a private party with respect to specific notifications and the broad definition of how they wanted slope movement. One thing I do want to add in that has come up a couple of times throughout this hearing today, Gunnison has a wonderful working relationship with the local government designees and their local governments. They have done a tremendous job of building those relationships, and they are in constant contact with that local government. While we cannot make or we don't have jurisdiction over what the local government does, we do know that the local government has always been responsive, and they do their best to keep parties informed, and we are proud of that relationship. And we would note that a blanket setback, obviously, we're opposed to just based on the various nature of how those sorts of things are measured and various factors. If someone has a question on that, I will turn that over to our geohazard person, that they're much smarter than I am. And then finally, the revision of geologic hazard risk analysis based on local warming and climate change variations, we believe to simply be untenable. And not that we're opposed to, reviewing things, but on a local basis, that's difficult to define. It's difficult, the parameters, and nearly impossible to effectuate. Next slide, please. Geohazards. So we also want to note we did an INSAR study done to have look at those landslides. The nearest landslide movement is over 8 miles to the east. We believe an additional study would be duplicative. Again, emphasizing we are in compliance with Rule 705, which is something they had requested. We do not see evidence of persistent movement west of the project area with the recent INSAR study, which again we did voluntarily. Going back to the geologic data, CGS and USGS have a publicly available website where the public can monitor seismic data. This would utilize the already in place infrastructure and allow public monitoring. Again, this would address their concerns, and they're welcome to review that data. And then, of course, Gunnison has a hotline where issues can be reported in the instance someone were to see a seismic spike on the CGS and USGS. Again, CHC's request for a notification to a private party with respect to slope movement could be defined, as we noted, in a broad way, requiring Gunnison to notify a private third party with no interest in the development on a consistent basis for each and every step of the process. Again, it's the broad nature and particular private parties. To add a specific private party to the notification process for such a broad term would put in place what could be proved to be a burdensome and untenable policy with no tangible benefits that were identified in their testimony or pre-hearing statement, and we believe it would be outside ECMC's current notification requirements. Next slide, please. And then finally, we do reaffirm our commitment as stated in our geologic hazard plan to provide that we will consider appropriate offsets to historical mine workings as may be required. Our working pad surface is 2.2 miles at the minimum from the nearest known coal mine. It is true that Gunnison's current plan keeps drilling at least 2.2 miles from coal mines when it's northern development. Gunnison believes that specific scenarios do require specific solution, and a blanket setback is arbitrary and capricious. We will continue to evaluate all aspects of offsetting coal mines in a three-dimensional space to stay the appropriate distance from any mine based on depths, geologic characteristics, mine status, and other safety factors. Revision of our geologic hazard risk analysis based on local warming and climate change variations would be, as we noted, an impossible task, and it does not fall within these current ECMC requirements, and we believe to be subjective. For example, one thing we'd like to highlight is during a recent precipitation event, which was abnormal and higher than normal, not only did Gunnison infrastructure handle the event with no interruptions, incidents, or accidents of any kind, but Gunnison was able to engage with landowners and the U.S. Forest Service and able to help remedy those entities impacted by roads and properties, something that Gunnison is very proud of. And it does show, we believe, their engagement in the community and willingness to work with partners. Next slide, please. With respect to wildlife, there was a discussion surrounding breeding grounds for the golden eagle. CHC requested, and they didn't get to in their testimony, but we do want to address it for this commission in case there's questions. They're requesting that we prove, in a sense, the negative. CHC's own statement acknowledges, however, that there's no current evidence of such a breeding ground. Rather, it is a potential with no evidence. CHC acknowledges Gunnison has previously conducted a bird study pursuant to its federal permitting requirements. We do want to point that out. Gunnison is obligated to follow federal law because there is a federal permit here, and it does address the very protections that CHC is requesting. We think that's important. Gunnison's federal permit has requirements that address the very issue CHC raised, and there's no documentation of an eagle's nest within 1 mile of the location as required under the Rule 1202 C1. Gunnison conducted a raptor survey for federal environmental analysis process, and we did not notify it. There were no nests identified. So pursuant to the federal APD condition of approval, Gunnison will comply with the Bald and Golden Eagle Protection Act and conduct a raptor nesting survey prior to drilling if activities will be conducted between February 1st and August 15th. Next slide, please. And one thing we also wanted to note with this map is, recently this commission undertook a high priority habitat rulemaking, and this is the updated maps. And we would note that ECMC's own data and high priority habitat map shows that there is no basis for an eagle issue or eagle nest of any kind. Next slide, please. There was an issue raised by spills and releases. Just to address, so the SBCC that was referenced in their pre-hearing statement was drafted and reviewed by a professional engineer, and it was conducted pursuant to Gunnison's federal requirement. It is not required for the ECMC permit. The ECMC permit does require a fluid leak and detection plan, which was submitted with the Form 2A. We would note that the specific concerns about Gunnison being required to submit specific spill reports directly to a private third-party group and additional private parties. ECMC rules are very clear on spill reporting, and they were designed to provide robust protections to the public. That was, discussed during the rulemaking when they were put in place. And finally, Gunnison did conduct a hydraulic study that was submitted as part of this permit that illustrates there is a nearly 0% probability that any spill could possibly reach any of the specified entities. Slide, please. Finally, there were some application questions, and Mr. Chairman, you had noted on that you had a question about those. So we'll just go kind of in the order that the four were raised. With respect to the production equipment question, Gunnison Energy consulted with ECMC staff prior to submission of the OGDP. Due to the fact that the IPU lower and Iron Point unit Hotchkiss 1291, 1324 locations are adjacent and the disturbances touch, the flow lines that will connect the IPU lower wells to the production equipment at the Iron Point Hotchkiss 1291 locations will be considered on-location flow lines. With respect to the synthetic oil mud system, it is part of drilling operations. Once the wells are drilled and completed and enter the production phase, there will be no production equipment on location. The difference between the truck traffic trips, which is the third question, between what Gunnison has provided in its ECMC permit versus the traffic table included with the federal NFMMDP permit, is the ECMC permit is for all wells proposed on this specific location. The federal permit traffic table is an average inspection per well across several different well paths. It's an important distinction. And finally, the 7,900 foot number is the depth of the wellbore below ground surface, or true vertical depth, and the 12,000 foot depth is the length of the wellbore or measured depth. Next slide, please. Finally, a couple of things, and then I do want to let Barrett address Commissioner McGowan's question. But we wanted to note this is the landowner statement for the owner of the location where the wells will be developed. We know that he wasn't able to be here today, but we very much appreciate him reaching out and providing us this letter. And I just want to read it to you to get into the record that the landowner is very supportive. So Mr. Jim Farmer, president of Hotchkiss Ranches, he is writing as an heir and as president of Hotchkiss Ranches. I assumed this role after my brother Kip Farmer, who was the president of Hotchkiss Ranches before me, died suddenly last year. Kip had always expressed to me the excellent working relationship that Hotchkiss Ranches has had with Gunnison Energy and their operations on our property. In my role as president of Hotchkiss Ranches this past year, I have been seeing firsthand the professionalism and pride that Gunnison Energy takes in their activities. They have proven to be excellent stewards of our land. Even before I learned of this permit hearing, I often commented to others about how impressed I was with the care that Gunnison Energy took to have their sites in a pristine state, and that they should be a model for others to look at and how to take care of the land. That said, I am hopeful as a landowner with the mineral and surface rights to the property where Gunnison Energy is operating, that the permits for their operation on Hotchkiss Ranch property are processed in a timely manner. Our family's ranch and the surrounding ranchers have needed to make significant, though tentative, business decisions based upon the pending approval of this permit, as ranching has faced tremendous challenges in recent years. The potential benefits that the local landowners could receive from Gunnison Energy's work could make the difference in some of us continuing our family ranching tradition. With this current permit, I have the utmost confidence that Gunnison Energy will continue to uphold their standard of excellence, and I strongly support its approval. And I believe he emailed this to each one of you. Respectfully, Jim Farmer, President, Hotchkiss Ranches. I believe so. In our conclusion here, and I know we give a closing statement, but we just want to remind and proffer that Gunnison has addressed all the concerns raised by the interested parties and public comments outside the interested parties. Gunnison has responded in detail to all public comments, again, not just those interested parties, but for the broader public, of which there were a few, and we responded to those in details. They are all submitted with this permit application in the packet. Gunnison has met or exceeded all ECM standards with this permit application. Gunnison's IPU application has satisfied all federal permitting criteria along with ECMC criteria. Gunnison's permit contains robust protections for health, safety, welfare, and the environment, and we would submit to you that Gunnison's permit should be granted. And then if Mr. Laverne could jump on real quick. I know he wanted to add one note to Commissioner McGowan's question about the geologic study.
Thanks, Chris. Yeah, it was just a statement that she made related to the rules, and I just wanted to reiterate that for the geohazard plan, which states in 304C21E that a simple estimate of level of risk associated with the hazard plan should be in the term of very low, low, moderate, high, or very high. And so I think we honored that rule. The other item I wanted to mention was the concern of evaluating geohazards outside a broader range of distance, and just wanted to cite the rule on the map. Excuse me, I think it's on the plan for the 1 mile radius, and we did honor that, and we did honor understanding any features that extended outside of the 1 mile radius. And with the INSAR study, that was a good tool for us to cover a large swath of land. So thank you.
Thank you, Barrett. We appreciate that. And with that, Mr. Robbins, I believe our rebuttal is complete.
Okay. At this point, well, you just sort of testified. I think we have Mr. Laverne. Does any commissioner have a question? All right, seeing no questions. I believe we have two other matters on the agenda before we close the record and turn to deliberations. First is the closing statement from CHC. Mr. Foote.
Yes, thank you.
As you know, you're long on time or short on time, so just but we do want to hear from you and kind of closing it out.
I appreciate that, and because I'm short on time, I'll just focus on one particular issue, and I guess a little bit of rebuttal from what we just heard from the operator, which is the operator has indicated, and they indicated several times, that they're willing to engage and work with partners. I guess I would add maybe a little qualification to that. They seem to be willing to work and engage with some partners, but not others. And clearly the folks in this coalition are people that they have not adequately engaged with or worked with. What we've seen with their explanations and written explanations, and also here today, is that they claim that they've addressed all the concerns. They certainly have written things down, but that's about the extent of it. They basically said, well, here's why we're right, and here's why we don't think your concern is valid. And they've certainly made a record of that. But as far as meeting the concerns of the folks in this coalition, it's questionable at best. One thing that I'll just highlight and turn it over to the other closing statement is this issue about notification. Notifying the LGD of Delta County is great. But what if Delta County has no procedure to notify the public? There's nothing that we know of. There's nothing in the record that they actually do that. So it goes into some kind of a file cabinet or somewhere, and it doesn't actually go out to the people that need it. It's pretty simple, or it should be, particularly for an operator that works with their local partners, to be able to copy folks on an email that includes notification of issues like spills or other events. It shouldn't be that difficult, and it certainly would go a long way in helping people. You heard Tara Ditch, representative, talk about how he has been notified about events before, and it's allowed him to actually take action quickly. In this case, I think what the operator has in mind is that Tara Ditch should be calling the LGD from Delta County at least once a day to make sure that nothing bad has happened, or that that person's been notified of that. Again, we're not asking for a lot here. It's not that big of a deal to copy folks on emails, and it would go a long way. So that's just one example of how the operator in this case really hasn't been addressing those concerns, and how the commission could go a long way in helping address those concerns. So it's a big risk. The folks that you heard from today have a lot on the line, and it would be hopefully incumbent on this commission to go a long way to help address those concerns in its decision on this permit.
Thank you for the closing. Mr. McGowan, did you have anything further with regard to closing?
Yes, Commissioner, I'll make it brief. I do have a quick closing statement. Real quickly, again, we want to thank you for your time. We know this is you have a difficult job and these discussions can be time consuming and challenging. As you've seen, Gunnison has met or exceeded every standard required by the ECMC. Gunnison has taken great pains to ensure the IPU permit considers all aspects of development, the public interest, and the broader concerns of the individual parties. We also want to know, we just really want to quickly give you a summary and highlight of Gunnison's efforts to commitment to development of its oil and gas resources in the most responsible manner possible. Gunnison has utilized existing locations to reduce surface impacts. Gunnison will use already in place production equipment, further reducing development time, impacts, surface impacts, and its overall footprint in the area. Gunnison responded to each and every public comment submitted in this manner. Gunnison has received its approved federal permit. Topsoil has already been segregated for future reclamation. Stormwater and erosion controls are already installed. Fugitive dust is controlled by applying water to location and access road as needed. Downcast lighting will be used. Closed loop drilling will be used. The drilling mud, freshwater mud, will be used for superior surface hole. Synthetic base mud will be used for the rest of the well. Tier 4 completions technology. Gunnison will use up to 70% of recycled water, as we discussed. Total disturbance after the interim reclamation is 0.604 acres. No production equipment will be on location. Pipeline takeaway is already in place for natural gas and produced water. Stormwater management monitoring will be performed every 7 days. There's a closed loop system. Gunnison will use only fresh water for dust mitigation. Gunnison will use industrial designed water for drilling. Gunnison will use recycled and industrial designated water for completion operations. Gunnison will use OBM, which minimizes water usage. No PFAS will be used. Gunnison prepared a voluntary potential spill analysis. Spill kit will be kept at Iron Point Unit Hotchkiss location. Drilling and completion supply water will be piped to location. Production equipment will be connected to natural gas and produced water pipelines. Utilize railroad to deliver sand. Gunnison commissioned a site-specific INSAR study. Faults and seismic activity will not impact wastewater within a 1 mile buffer of this location. Faults and seismic activities to minimize wastewater injection. Gunnison will recycle produced water as much as possible. Gunnison acquired geotechnical borings, reducing estimated risk from low to moderate to low. Continuous emissions monitoring, minimize truck traffic emissions. Water for drilling and completion operations is planned to be used, piped into the location. There minimize traffic emissions further by utilizing the railroad to deliver sand for completion operations. Gunnison plans not to flare vent natural gas during completion or flowback. Gunnison has pipeline takeaway for natural gas and produced water, limiting truck traffic. There's no tanks on site. Gunnison will use a Tier 4 completions rig. Gunnison will defer routine non-essential activities to non-high ozone days. Existing IPU production facility will be upgraded to no bleed pneumatics. Minimize truck traffic emissions is, well, again, we're sorry about that. Gunnison plans, Gunnison will, the lighting will be downcast. The lighting will be directed to task areas only, and no permanent lighting will be used on locations. While this list is comprehensive, it is not exhaustive. In other words, Gunnison has put forth a permit application that meets and exceeds all ECMC standards and addressed all the concerns raised by the public and affected parties. We understand there was some outstanding that Mr. Foote had concerns about, but I would note that I know that he is a proponent of local control. And so we want to emphasize our partnership with the local communities where this development will be had. And we are proud of the commitment that Gunnison will continue to work with those local communities in the best manner and most efficient manner and most transparent manner possible. Again, in this, we do appreciate your time and consideration, and we look forward to your approval of the IPU lower permit application.
All right. Thank you very much. I believe we've gotten through the conclusion of the witness presentation on this hearing part. Next, we would turn to thoughts amongst commissioners. I, for one, would love to take 10 minutes before we do that. So if we could return at 2:37, and then we'll get into deliberations.